the meeting open to the public. Can I advise members that the committee meeting will be recorded and broadcast throughout Parliament buildings and online? Can I advise members and those in the public gallery that they are welcome to use mobile devices as long as they are in airplane mode and all devices are muted? Attendees can also connect to the Assembly Wi-Fi and password details are available on the gallery rules. It is not permitted to take photographs or record any part of the meeting. Can I advise members that it is proposed that the oral evidence session with the Justice Minister and the committee deliberations on the Justice Bill with Department of Justice officials in attendance will be recorded by Hansard, and can I seek your agreement for this? Agreed? Agreed. Can I remind members then that they are obliged to declare any financial or other relevant interests that might reasonably be thought by others to influence their approach to the matter under consideration. Any members who have interest to declare can do so now. Okay, I'm going to just put the wide one of the all-party group, if that's okay. Connie, remind me the title of that.
All-party group of access to justice.
Thank you very much, and that goes for all of us who basically attend that. Okay, agenda item number 3 then is draft minutes. Inform members that the draft minutes of the meeting held on Thursday, 29th of January 2026 are pages 316 to 326 of the meeting pack. Can I ask members if they are content with the minutes and that they are a true reflection of the proceedings of that meeting? If they agree, then I will sign. Agreed? Mm-hmm. Okay, agenda item number 4 then is matters arising. Can I ask members if there have any matters arising from the minutes they wish to raise at this point? No. Okay then, agenda item number 5 is Ministerial Briefing, Minister of Justice, Oral Evidence. Can I refer members to page 328 to 348 of the meeting pack for the relevant papers, as well as the Minister's response to the committee on the draft multi-year budget at pages 3 to 10 of the table pack, and the legal advice from the Assembly Legal Services at page 11 to 18 of the table pack. Can I remind members that the legal advice is subject to legal professional privilege and should then not be discussed or directly quoted from in public session. Can I advise members that the draft multi-year budget response is included for reference due to the Minister attending today. Okay, but this item will be discussed in further detail with officials when they give evidence to the committee on the 19th of February. Can I also remind members that at its meeting on the 20th of November, following oral evidence from the Departmental Permanent Secretary on Sagini's Transforming the Criminal Justice System in Northern Ireland report, members agreed to invite the Minister for Justice to provide an update on departmental priorities. So can I remind members that they were asked to provide details of any matters that they wish to raise with the Minister, though were advised that this would not preclude other matters being raised on the day. As members will see at pages 3 to 9 of the pack, only 2 issues were raised, but I'm sure other members will raise other questions which are topical at this time, and they're quite entitled to do so. What I will say is we're all very busy people, and so is the Minister of Justice, and an hour and a half, Minister. So we are limited. So I would ask then that you just be careful with your time. Make sure you ask direct questions, and we don't need statements or opinions. We just need questions and answers. And Minister, of course, that would go for you too.
Thank you, Chair.
So without further ado then, we'll try and get through a very good, productive session with Minister of Justice Naomi Long, and with Hugh Wittis, the Permanent Secretary, who has also joined the Minister today. So you're very welcome here to the committee. Maybe you want to make an opening statement?
I would be grateful if I could. Thank you, Chair, and thanks to the committee for the opportunity to meet with you today. I know that officials have been attending the committee regularly and trust that has been helpful. My officials and I are very keen to support the committee in your important role of scrutinising and supporting the department, and we're really grateful for your input to the work of the department as we seek to advance our priorities. I normally plan to keep my opening remarks brief to allow as much time for questions. However, I would ask you to indulge me slightly, as given the events of recent days, I would like to provide some additional information than I'd originally intended to. I do want to touch on a few current issues, and of course we'll take any questions. Since I last attended the committee in March last year, I'm pleased to report progress has been made on a number of key issues. I was particularly pleased, for example, in such a challenging financial environment to secure full funding of $7 million for year one of the PSNI Workforce Recovery Plan, and that recruitment campaign, as you know, is ongoing at the moment. The department also secured $20.5 million in transformation funding from the Public Sector Transformation Board earlier this year to support key elements of the Speeding Up and Transforming the Criminal Justice System programme. The funding supports two priority projects, early engagement and out-of-court disposals, both of which are key enablers for the wider programme and also deliver their own benefits, including improvements in reducing avoidable delay, how cases are progressed and a more proportionate use of disposals. A public consultation regarding the expansion of out-of-court disposals concluded on the 28th of September. The findings have been compiled and the next steps will be discussed with yourselves at a meeting on the 19th of February. I also recently launched a review of sentencing policy which will consider the legislative framework for categories of crime, including serious sexual crimes, drugs, fireworks and animal welfare. The use of good character evidence and prison sentences for unlawful killing of an emergency worker while on duty will also be considered as part of that review. A children's sexual offences legal advisor pilot has been launched to support young victims of serious sexual offences to navigate the justice system. A major challenge this year, and particularly going forward, is finance, and it will severely impact on my department undertaking initiatives. While funding allocations for the current financial year have been largely positive for my department, we cannot forget they are only slowly closing a gap which was created by significant and consistent underfunding over the last decade. This continues to impact on a range of areas, not only policing but also prisons, courts, legal aid and probation services. Action continues to be taken by all areas of the justice system to bear down on costs in order to keep expenditure to a minimum. This will ensure that my department does not overspend its budget allocation for 2025-26. In terms of future multi-year budgets, however, I'm very conscious of the significant pressures facing all departments and the difficult decisions that need to be taken by the Executive. However, I am particularly concerned with the proposed draft budget allocations for the Department of Justice. My department's finance director is due to provide the committee with a detailed budget briefing on the 19th of February. However, at this initial stage, the department's assessment is that business areas across the justice system will be facing stabilisation pressures for day-to-day running costs amounting to £101 million in 2026-27, £141 million in 2027-28 and £215 million in 2028-29. This would be catastrophic for the justice system in Northern Ireland, and considering the magnitude of the pressures remaining, it is difficult to see how my department will manage to live within budget. I'll continue to work through the details of the proposed draft budget outcome with my officials and business areas across the department. Some extremely difficult decisions on prioritisation and service provision will be required to manage those remaining pressures, and this will inevitably involve consideration of issues such as services that can be delivered, staff numbers, pay awards and deferring major capital plans. I remain committed to working with the Minister of Finance and my executive colleagues to ensure that we have a justice sector that is funded appropriately. I trust that you will be supportive of the need for investment in the department, and I'm sure you've been hearing similar views from stakeholders. I've also been taking steps to improve the use of resources and ensure the effectiveness and efficiency of the justice system. But it is not a straightforward or easy task, as the withdrawal of service by the Criminal Bar Association demonstrates. There is a clear mandate for change and clear support for change among most stakeholders, but at times there is also a degree of resistance to change, a lack of understanding among some about governance and legislative constraints, and a lack of realism about the financial pressures we are facing. It is disappointing that the CBA decided to increase pressures on the system. The action gives rise to additional costs, and costs will attach to recovery also. More importantly, it is disappointing that the suffering of victims and witnesses is now being leveraged yet again, and they remain my primary concern. As I've said before, the impact of the withdrawal on victims and witnesses cannot be overstated. However, I remain determined to make progress. Indeed, I was hopeful of a positive outcome by the time I sat here before you. I had proposed an accelerated independent review, investing additional funding and departmental resources once again to address the remaining concerns of the CBA at pace. The proposed review was conditional on a full return to service to remove the intolerable impact victims and witnesses are currently suffering. It was also to ensure additional unwarranted pressure was not being brought to bear on those leading the review, that they could proceed without fear or favour and without the leverage of victim suffering influencing decision making. Unfortunately, the CBA have rejected that proposal, suggesting instead they decide on a week-to-week basis if any further derogations to the service withdrawal could be allowed, subject to their assessment of progress. As you will appreciate, that is untenable. And I would argue it is also unethical. I cannot allow victims and witnesses to be blatantly used as bargaining chips in any process. I cannot allow the independence of reviewers to be compromised. The review needed clear and unambiguous commitment from all at the outset, and my commitment was clear. The offer of potentially considering allowing further derogations would also offer no degree of comfort to victims and witnesses. They would have no certainty as to if or when their case might proceed, and there would be no clarity as to the criteria the CBA committee of unknown barristers making the decisions on derogations would apply and deciding which cases would go ahead. Given that my offer was rejected, I cannot therefore proceed with the accelerated review, and so the Burgess review process will continue as originally scoped. I have also asked my officials to consider other options for resolution. That work is ongoing. Officials are meeting again with representatives of the Bar Council this afternoon, so I can't say much more at this stage. But please be assured work is intensive and proceeding at pace, and that this is a priority for me. I'm also working at pace to increase support for the victims and witnesses affected by the service withdrawal. I'm making additional resources available so all possible assistance can be provided, and officials are liaising with the organisations providing direct support to ensure the right individually tailored supports are provided at the greatest possible speed. In relation to the Justice Bill, I'm grateful to the Committee for the positive engagement it's had to date through written and oral evidence sessions with my officials across the range of areas, including proposed amendments. Members will be aware that I've secured executive agreement for the progression of the majority of the proposed amendments of the bill, some of which have already been drafted. This excludes, however, for now the draft proposal on the repeal of vagrancy, which has been parked temporarily by executive colleagues to allow for further discussion on that matter. This includes further engagement with the Committee, which I consider is best placed to scrutinise the detail of the provision. I will, of course, continue to engage with executive colleagues on the matter. In light of that continued engagement, the readiness of the draft provision and the broader interest already expressed on the issue, I believe the matter should be progressed to consideration stage when the Committee's final position can then be shared with Assembly members as part of that wider debate. Since committee stage began in September 2024, a number of additional policy areas have come to light where there is an urgent need for primary legislation. The Justice Bill is the only Assembly bill in this mandate that has the scope to capture these further provisions, and accordingly, as highlighted, I sought and secured executive agreement for the drafting and inclusion of additional policy areas in the bill. Members will be aware this includes a provision for new offences to criminalise the creation or sharing of a sexually explicit deepfake image. I hope to be able to share the text of the draft provisions with the Committee at the soonest opportunity, and if possible allow the Committee to consider and include the outcome of their deliberations on those clauses at report stage in the Committee. However, irrespective of that, and given that drafting resources are outside of my direct control, I do intend to move the amendment at consideration stage. With committee stage due to end on Friday the 27th of March, I would be hopeful the Justice Bill could complete its remaining Assembly stages before summer recess. Consideration stage could take place at the end of April, start of May, and further consideration stage in late May, with final stage in mid to late June, subject to Executive and Business Committee approvals. If royal assent were then granted over the summer, the first of many of these long overdue reforms would be able to come into operation in the autumn. Some, however, will require further time to enable preparation for their effective readiness in conjunction with our operational partners. Following pre-legislative scrutiny of the proposed provisions included in the Victims and Witnesses of Crime Bill, instructions have now been prepared for OLC, and work is progressing with the aim of introducing that bill in late spring. I believe the contents of the bill are necessary, and I've focused on the reforms that I believe will be most impactful to effect real change for victims and witnesses of crime. Following the Assembly debate on the 8th of December, Minister Kimmins and I met with families and representatives campaigning for legislation to prevent the unauthorised recording and sharing of photos of road traffic collisions and indeed other sudden deaths in the public space. It was clear the immense trauma that these families have faced in losing a loved one was further compounded by the circulation of distressing and graphic images on social media. I consider that the Victims and Witnesses of Crime Bill may provide a suitable legislative vehicle for such a provision. Whilst my department would not have the capacity to consult on these matters in advance, my officials would be willing to support and work with the committee to enable a committee amendment to that effect if members were minded to do so, and I would be interested in your views. Members will also be aware of my intention to introduce a sentencing bill. I intend to seek approval to introduce the bill at the executive meeting of the 12th of February, and subject to approval, intend to introduce the bill during the week commencing the 2nd of March. I understand a briefing for the committee will be arranged to follow shortly thereafter. Finally, I want to address the story reported yesterday regarding names appearing on court lists. Firstly, it is important to note that the Department does not accept that this is a personal data breach and no information was released erroneously. Court details other than those relating to family proceedings are routinely listed publicly online unless an application is made to the court for anonymity in line with open justice principles. It is the responsibility of the legal representative or parties to proceedings to make such applications. A decision to grant anonymity cannot be made by administrators. Only a judge can make that decision. Prior to yesterday, there is no record of an anonymity application being received by Northern Ireland Courts and Tribunal Service or granted by the court in relation to the cases that were listed. However, having been alerted by one of the parties to the cases, as a precautionary measure, my department took immediate action and made the decision to have public court lists online taken down from approximately 8:30 p.m. on the evening of the 3rd of February 2026 until 6 a.m. on the 4th of February 2026, when refreshed lists were available following the application of an interim judicial direction. This was done as a precaution and not as a result of it having been a mistake. I'm advised that the cases were listed before the court yesterday and that there may be other similar cases in future. As I've said, any applications relating to anonymity are a matter for the court. It is important to note that other than potentially the description of the defendant by name, nothing on public court lists identifies an individual police officer. Others who are not police officers or police staff may also on occasion take action against the PSNI. There will continue to be cases taken by police officers or staff against the PSNI, and that will appear on court lists where there has been no application for anonymity. But as I said, it is the responsibility of legal representatives or other parties to proceedings to make that application to the court and to make that case to the judge. Some have asked why there is not a court process to prevent police officer names being released through the courts. There is a well-established process. An application for anonymity can be made to the court by a legal representative or parties to proceedings, but it is the responsibility of the legal representative or the parties to proceedings to make the application. I hope that this clarifies the Department's position, and I'll finish there, and I'm happy to take any questions on these or other issues.
Thank you, Minister, for that presentation. You covered a lot of issues within that. First, I think we'll welcome all the sentencing bill coming forward 2nd of March, and then also in the springtime the Victims and Witnesses bill. You did talk about the committee helping or assisting you with an amendment with regards to the issue you raised there about the photographs. I think the committee would be very willing to explore that with you. I suppose my question is, would that then open the Victims and Witnesses bill up in scope to open it up for other traffic-related offences?
No, I don't believe so, Mr. Chairman. I think that first and foremost we would want to narrow the scope. I don't think we would want to narrow it so much that only road traffic victims would be incorporated. So, for example, I've had other situations where there was a sudden death in a public space, or where there was some other form of accident or incident, and similar photographs were disclosed on social media. So I think we would want to focus on those kind of sudden incidents rather than specifically road traffic issues. And also, because of the nature of the scope, we are looking at how we could draft that to allow the inclusion of this protection for victims and witnesses, as opposed to opening the scope more widely for additional clauses. But that is something that we can work through with the committee if the committee are minded. As I say, for the department to take this forward, we would need to undertake a massive consultation exercise for which we simply do not have the resources or time. However, for the committee to do this, it would be much easier in terms of scoping the work, and the department is more than happy to play its part in terms of providing background information and assistance to assist with the drafting of any clauses.
Okay. With regards to the strike, the barrister strike, we have had communications. I suppose all of us have had communications with the bar and then with yourself in the department around this strike. There was hope of a meeting of minds, and you have met with the chair and vice chair of the Criminal Bar Association, CPA, I think on the 15th of January. At that point, you've already alluded to an accelerated review taking place. You say that the CBA haven't lived up to the conditions on their side of things. They would say that there were milestones that were included. 23rd of January, scope of review agreed by all parties. 30th of January, terms and reference agreed and review commenced. And then no later than the 20th of March, report with findings and recommendations submitted. Minister, why is it that when you've met with them before these markers, these milestones, have you needed more time, and why have you not appointed the co-leads?
Well, the first thing to say is that, and I'm aware of the correspondence that has been circulated, and I haven't had time to consider the most recent correspondence that has been circulated, and so I wouldn't want to try to rebut it on a point-by-point basis. However, I would be fair to say that it isn't, in my view, a fair recollection of the meeting that I attended, which was a positive and constructive one. When you set down an offer, there are terms and conditions attached. And one of those terms and conditions was that the bar would initially return to service in those complex cases. So I guess revert to the position they were at before full withdrawal of service. And that then when the actual review, the SWIFT review started, that they would return to full service. That is to ensure that there's no further damage done during the period, but also that it ensures that the bar would not continue to use vulnerable victims and witnesses of serious life-changing, life-ending events would not continue to be used as bargaining chips and leverage in this process. And I think that from an ethical and moral perspective, was important. On the 23rd of January, we had only then received from the SCBA and the CBA an initial response, and therefore were not in a position to set out the terms of reference at that time. But I did write to the bar the following week and explained the delay in that regard. We also set about appointing the joint leads. Tom Burgess was to be one of those joint leads, and we then sought a consultant from either SIB or on their recommendation to come in to do the economic appraisal work. And we did struggle to get someone who was willing to take on that piece of work. However, we were able to identify someone. However, fundamentally, the CBA did not agree on any phased return to work that was structured. They simply said that they were willing to possibly consider allowing the derogation to apply to certain cases. I have no sightedness on who the people making that decision are or what their expertise or skills are. Those derogations were sought by people in PPS and Victims and Witness Care Unit and Victim and Witnesses Support based on vulnerability. And I feel that it would be wrong to enter into a process where there isn't reciprocity. If the argument has been that there is a lack of trust, then I'm willing to work to restore that trust. But that requires them to meet me halfway. And for me to invest further resources in an expedited process with no promise of a full return to service is something that I simply couldn't countenance.
Minister, what is the real difference between the process that you're in at the minute with the Burgess review and any accelerated review, notwithstanding any negotiations you would have or any commitments that you would want from the barristers? Why would it not be better to go through an accelerated process?
Well, the reason is, first of all, that it was going to cost time, resource and money that we have in very scarce amounts. So that is one reason why it is challenging. The second reason is that it was going to look at a very small number of issues, particularly those which were of concern to the criminal bar, and then a smaller group that were also brought forward by the SCBA, because I have to say I was very clear from the beginning that I do not want to be in a situation where the baby that cries the loudest gets the feed and the other gets ignored. The SCBA have complied with everything we've asked in terms of provision of evidence, in terms of provision of justification for what the further asks, and as a result of working with us while continuing to service their clients, we have been able to progress many of the issues they've raised. However, in an accelerated process, it was important for me that they got equal time and attention in terms of taking their issues forward. There would be other issues that would still have been part of the normal track of the Burgess reviews. This is a very narrow number of points, because they were the ones, frankly, that were indicated to me that if they could be resolved expeditiously, would secure that return to full service. However, in the end, that return to full service was rejected by the CBA membership. And therefore, I think it is incumbent on me to now continue with the process as was originally envisaged. Because the only reason we were investing in this was to get people back to work to save damage. This is going to cost us money. This withdrawal of service is going to cost us money in terms of recovery, in terms of additional support for victims and witnesses. The purpose of me taking some of the investment that we will need for that and putting it into the accelerated review was to try to get people back to full service, where we would then make those savings that would, if you like, that would recoup what we invested in that accelerated process. What I don't have the resources to do, quite frankly, is to run an accelerated process and deal with the recovery of the ongoing damage. So it's got to be one or the other.
Minister, I think it's fair to say that confidence in justice is at a very low ebb. The lack of trust with the criminal barristers, victims are devastated. The general public out there seems to have a really low opinion of justice and the procedures. What do you have to say to the families that have been impacted by this, not least constituents of mine, the Mitchell family?
Well, I will be meeting the Mitchell family actually in the coming days, and I've arranged to do that. I have met with many victims and witnesses, and I've been very clear with them that I do not accept that what is happening as a result of this withdrawal of service is either ethical or meets the barrister's own code of conduct. The withdrawal of service from existing cases is not permissible under the bar's code of conduct, and yet that is what is happening. Their pain and their grief and their trauma is being leveraged in order to try to extract more financial benefits for barristers from the department. Now, I cannot stand over a process that allows them to be used as bargaining chips. I have been clear all along that I want to resolve this. I have proven by my engagement with the SCBA that where they can provide the evidence and work with us collaboratively, we can resolve issues. So I've given examples of the parole pilot, the work that we've done around PACE visits and so on. All of that has been resolved, even issues which may seem trivial to some but were significant for small companies, for example, the travel to court issues. All of those have been resolved with goodwill. I want to work with the CBA, but unfortunately now on at least 2 occasions I've sat with whatever the current leadership makeup was. We had a constructive and productive conversation. They felt that we were getting close to resolution, and I would hold up, for example, the issue of the decisions around refresher fees, and they have said in their latest correspondence that that has been resolved. That resolution has been on the table from this department since last August, in the precise terms that it has now been accepted. So all I can do is my best, but I need to be met with people in good faith who are determined to see this strike brought to an end in order to make real progress. The most recent offer I thought was eminently sensible and reasonable. It allowed barristers to continue to take on new cases, to benefit actually from the refresher fee pilot, which they won't benefit from until they start attending the court again. They would have, of course, if it had been agreed in August when we first proffered that offer. But I can't account for the internal dynamics within the CBA and the committee. So that's work they have to do. I will work with my department and my officials to try to be reasonable. I am not about trying to deny people a fair day's pay for a fair day's work. No one in this room would expect me to say otherwise, nor am I about trying to provide a second-rate service for those who require legal aid in order to access justice. I see legal aid as a valuable and essential part of our wider welfare provisions in this society. I have to, however, have transparency, openness and accountability in terms of how those fees are paid and for what. We have now got resolution, and that, for example, is an example of where, when we were looking at the accelerated process, we actually took that further forward out of the accelerated process and resolved it within days of my meeting with them. I would have thought that would have built the confidence and good faith that we were serious about the accelerated review. But unfortunately, it wasn't reciprocated with any seriousness about returning to full service. And that's the point, that's the sticking point. So look, I will continue to try and find alternative methods. I will continue to put forward reasonable and rational ways forward. But ultimately, I am concerned about the victims and indeed the clients of the barristers, many of whom are defendants in these cases and whose lives are also facing irreparable damage. If we cannot get those cases to court and proceeded with. So I think it is incumbent on everybody to do all they can, but I can only guarantee that I will do all I can, and it is for others to justify in however many pages they wish their decision to walk away and not reciprocate on that basis.
Minister, we've had one of the biggest data breaches in history, probably, with regards to the PSNI. And then we have what happened over this week, 41 police names on court listings who are taking a challenge on that specific data breach. Is it fair to say that they were named because of normal court process? And should there not have been some foresight into how we would handle cases like this, given the fact the challenge is coming from police officers who are currently serving, who are under threat, whose lives could be at danger, and who are challenging the PSNI?
Well, first of all, there could be no foresight because it was not known to us, for example, and would not be known to us at an administrative level whether or not legal counsel had sought anonymity. The granting of anonymity is a judicial function. It must be applied for by the legal representatives of those attending court. In the interest of open justice, we provide court listings as a matter of routine, and people are aware that their names, when they are in court, will be listed on those court listings. So those are pulled through onto the site in the normal way. And it is for those, and we have legal representation there who are familiar with the process for seeking anonymity. To be clear, there are many police officers who appear before the courts and do not seek anonymity. Whether it is given evidence in cases, whether it is taking a case against the PSNI or someone else, whether it's in a private or a PSNI capacity, and don't seek anonymity. There are others who will seek anonymity and a judge will refuse it because they don't believe that it is justified in those circumstances. There are also many people who take cases against the PSNI who are not police staff or police officers. And our administrators in the court service would have no means of knowing the individual nature of each case. That would involve an intrusion into people's private data and their case that would exceed the boundaries of what we are allowed to do. So the process for this is absolutely clear. However, when this was raised with me by one of the parties to the case, my officials immediately took action in order to protect those who were concerned about the matter and to limit any potential issues. We didn't do it because we had made a mistake. We made no mistake. The 41 officers listed on the court website had not sought and were not granted anonymity. That's a legal fact. So what we did in terms of our response, having sought a judge to make an interim direction, was when we realised the system will only refresh at 6 a.m, then I said, well, then let's take the system down. Take it offline, and that's as far as we can go. But that wasn't because we had made a mistake. It was because we were aware people were concerned that the names were online, and it was an extraordinary intervention by my officials above and beyond what is required of them in order to try to provide that reassurance. But there was no data breach. Your name is not protected data in the court system, And only if you seek anonymity from the court officially through the judge will that anonymity be granted. There can be no automated procedure because we do not know every officer, nor would it be in the interest of open justice for every officer to be automatically granted anonymity in every court listing.
Yeah. What is the current state, Minister, of the listings? Are they back up, and are the names back up?
They were restored at 6 a.m. when they had
system refreshes overnight or whatever, and it comes back on. It was something like 6:30 this morning, and that's all the lists for all of Northern Ireland. The names that were there previously are not there.
That was an interim judge direction. So the judge made
the names.
So our officials approached the judge. The judge made an interim order that the names could be granted temporary anonymity until such times as the legal team representing those officers was able then to make a formal application.
Given that, Minister, and given that intervention that you've made, how do we move and proceed in the future with similar cases for which there will undoubtedly be some with regards to the data breach? I understand what you say about police officers in court for all various types of reasons, but specifically around a data breach that they feel that they must challenge the PSNI because of what it has done to their lives. How will we be able to proceed with cases similar?
Well, Chair, two things. First of all, we won't know if those cases are to do with the data breach in terms of their listing. We are not cited on that. We are cited on the complainant and respondent. But we would be taking a guess. It could be anyone taking a case against the PSNI, so we can't be sure. We also can't preemptively assume that a judge would grant anonymity simply because it was requested, which is the other part of this. The only way to resolve this is for legal representatives to make the appropriate applications at the appropriate time. Helpfully, the Chief Constable has circulated to all PSNI officers today, first of all, a reminder that the onus is on them and their legal representatives to seek anonymity if they so wish, and secondly, that there was no error on behalf of either the PSNI or the Department of Justice.
Last question I'll put out to members. Do you see this as having a chill factor on people coming forward to have their day in court?
No, I don't, because I think that their legal representatives are able to manage any concerns they have around anonymity, and in the same way as in all of the cases that were listed where anonymity was granted, people will have the opportunity to do that. So there is no chill factor required. Ultimately, I can be held account for those things for which I'm responsible, but what legal representatives do is not one of those things.
Okay, thank you, Minister. Emma?
Thanks, Chair. Thanks, Minister, for coming in. I want to go back very quickly to the questions that the Chair had asked around the strike at the minute. And you referred there to potentially having to consider alternative methods if this continues. What sort of thing are you?
Well, we're obviously at the moment looking at how we navigate through the system. So there are a number of things we've had to allocate additional resources to support for victims and witnesses. There will be those who are fearful for their safety. There will be those who are still at risk from the alleged perpetrator of the abuse that has led to this court case. There are others who require additional support, counselling and so on in the interim. And so we are working with those who work directly with the victims to ensure that they get the support they need and to try to stave off any potential attrition in victims and witnesses through this process. Because it is an incredibly painful process. And these people, to be clear, these are not strangers to me. And I sat in Natalie McNally's parents' home and I met with that family. You know, I attended the vigil for Chloe Mitchell and met her family. I know what they are going through at this point in time. And it is unconscionable that their pain is being leveraged in this way, as far as I am concerned. What I need to do now is look at, without prejudice, without allowing the frustration that I clearly feel and the upset that I clearly feel about the plight of those victims, is to find another way forward. Because I want this resolved. I want barristers back at full service. I want these cases back in the court. So we will go away, having our last offer rejected. We will regroup and we will consider alternative ways forward that we can actually get this resolved, because that is my number one priority. In the longer term, we will have to look at potentially alternative ways of providing legal advocacy services, because we cannot be in a situation where periodically we end up with cases, and in fact the whole justice system, being held hostage in this way by any one sector. People have a right to withdraw service, though that right, I have to say, is limited even by their own code of practice, in that you can refuse to take new cases but not refuse to service those cases that you have. That was made very clear when the Bar Council wrote to all members of the CBA. It's for them to enforce, but that's clear. But this cannot continue to happen. It is damaging to the justice system. It is damaging to our work to try to speed up justice, and fundamentally, it is traumatic in the extreme for victims. What is almost worse, and this is why I wanted a very clean process to get back to full service with dates attached, is for many victims, their case will be on review every 2 weeks. And they will be preparing themselves to go to court and hoping above all that that will happen, only to have their hopes dashed again, and to go through that every 2 weeks. It to me is dreadful, which is why I thought if we could set dates when we could actually say this will be partial service resumed, this will be full service resumed, there would be certainty in that. But simply saying we may consider further derogations offers no certainty to victims, and those who I have met are desperate for certainty about when their case will be heard. The justice system is unpredictable enough without having this additional level of unpredictability around it, and I want to bring that to a close. So look, I will re-engage. As I say, my officials are with the CBA later today, and I will personally re-engage, as I always have, in good faith, to try to get this resolved, because that is my priority.
Okay, thanks. If I can come in again on that. So you've outlined a lot there, and you did in your previous answers, and obviously the relationships have broken down somewhat here, and you referred to the fact that you're aware we've all received correspondence from the CBA where they, I suppose, have asserted that they believe that delays from the department's side have caused a breakdown in trust, and that's why they feel that they couldn't engage, and the slippage, I think, is the term that they used. I suppose what I'm concerned about, and you referred there to a number of victims, and we all probably have constituents that this relates to. I'm concerned that perhaps there is a scenario now where we have one group of vulnerable people perhaps pitted against another group within society, and I'm particularly concerned for victims of crime, where oftentimes those most likely to be victims of crime are people from minority communities, women, working class people that are from areas of disadvantage. And those same sorts of people who are entering this profession are those who struggle to enter the profession, given the low rate of pay when you're in the early stages of that career, and how difficult that it is to break into. And I know they've explicitly referred to an answer that you provided to myself in the chamber around the hoarding of cases and how they felt that was unhelpful. So I suppose I wonder how we can...
It was accurate, if I may say, Chair. It was accurate.
Well, they have a different perspective on that, and I know, and I acknowledge that you said at the outset that you hadn't had an opportunity to go through each of their points case by case and refute them all. But I suppose my concern is that I would love to see us taking the heat out of this, and what mediation there has been, and how we can have this conversation in a way that everyone is taken at face value, and that we don't have this he said, she said, which we have seen a bit of, which probably isn't helping the situation.
Look, in terms of he said, she said, it's not about he said, she said. I can evidence that a small number of barristers hold the majority of legal aid cases. We have the evidence to prove that. It may not be helpful to the CBA for me to say that, but it's a fact. And it's one of the reasons why young barristers in particular struggle to be able to get experience. One of the things we've been looking at as part of the wider Enabling Access to Justice programme we've been looking at is about trying to change how we manage the different court tiers, to allow more junior members of the profession to be able to gain the experience so that they're able to earn a living. There are junior barristers who are afraid. There are junior barristers who are afraid to submit bills for their work. in case they don't get further work. Now, that's not something that we can deal with in terms of legal aid, but we can ensure that they're properly paid for the work that they do. But if you have more senior people who have the lion's share of all cases, the money that we spend on legal aid in Northern Ireland is far higher per head of population, twice in Northern Ireland what is spent in other parts of these islands. And so it's the distribution, this is really important, it is the distribution of that income across the profession that is the challenge for junior and indeed female barristers. So that is what we are trying to resolve. The issue with refresher fee pilots, for example, part of the issue there is to ensure that more junior members of the profession are able to get opportunities to gain experience. Because if you have a situation, which we have had, where people who have a case in one court are claiming a full day refresher fee in that court, but aren't in that court, are in another court down the road claiming fees there, and then rushing back in the last 15 minutes, A, the client is not getting the service they paid for, and that a judge decided they needed. And secondly, that is one barrister holding down two jobs at the same time, which could provide work for another barrister. So what we have tried to do is set the refresher fees at a level that means they don't need to do the running between courts, that work can then be freed up for others to take forward, and also then look at the other fees. I am open, and I have said this repeatedly, I am open to further fee increases, but it was not me who made the judgment that the evidence was insufficient. It was His Honour Judge Burgess, who said that all he could substantiate based on the work that had been done and the evidence presented by the CBA and SCBA was 16%. The SCBA have continued to work with us, provide further evidence, and we have gone on to increase further some of the areas of work where they were concerned. If the CBA, they said in their letter, I note, it would take an afternoon to provide the evidence. Well, the question is then begged of them why they haven't provided it to date. Because we've been at this process now for a considerable length of time. It is for them to evidence the work that they do, the complexity of it, the time that it takes, in order that we can then work out what the right fee structure is, and I'm willing to do that. I don't believe relationships have broken down. I think actually that in itself misrepresents the position. When I'm in the room with the CBA, relationships are fine. They said that they did trust what I was trying to do was genuine, as I trusted them. I was public in saying that I thought we had an opportunity to resolve it. When it comes to responsiveness, and I get the point that they make, and I'm willing to concede that we were a couple of days late on the first deadline. We were waiting for the Solicitor's Criminal Bar to come with their asks, and that did delay things. We also have, as everyone has, some unsurmountable challenges. When you try to find a consultant and you struggle to find one willing to take on the work, there's only so much we can be held accountable for, but we eventually managed to find the consultant to do that. That was some slippage in time, that I will accept. I had an offer on the table from last August, during which time they signed up to continue with the process and then withdrew full service, and have now accepted on refresher fee pilots. Now, if that isn't slippage for no good reason, what is?
So just if I can come back, and you covered this at the outset of your answer, it's just, I think their point of consternation was around the use of that language, hoarding, and they have sort of clarified how you know, the process as to how these cases are divided out and how, you know, they're instructed by solicitors. And I suppose it's just that narrative perhaps is maybe unhelpful, and where I'm picking that up in the media and how this is all being presented.
I can stop calling it hoarding, and I can do what I just did and say the distribution of cases across the profession is the fundamental problem with young barristers and young women in particular receiving a decent income as part of their profession. It is not the fee structure of the department. If you do not have cases, you do not earn money. So the fee structure is irrelevant if those young women and young men do not have cases. And that is the bottom line. So what we have tried to do, we've introduced things like interim payments, in order to try to see, to ensure, for example, I'll give you an example of a problem where someone is preparing for court and they do preparatory work, and the trial, they get pregnant, and the trial happens when they're on maternity leave. That case will pass to somebody else who will be paid for that work. But the person who did the preparation and initiated it won't be paid. Now that has to change, which is why we're talking about interim fees. So you get paid as you go along for what you've done. And that is fair to protect people in that situation. I mean, these are all issues on which there is, I think, overall a wide amount of agreement. The profession themselves are concerned about the stability and future-proofing of the profession. Because as with all professions, as people age out of the profession with their skills, you want to make sure there's a cadre of people coming underneath who have those skills. But the only way to gain those skills is to distribute the cases across the bar. It will not be the same case. The complex cases will always go to the most senior people. But there are other cases where people are running into magistrates' courts, for example, senior counsel in magistrates' courts for non-complex cases, but are getting fees for that. That's work that a very junior barrister could theoretically be doing and gaining experience, which they could then build on. This is what we want to look at. So I don't think the gulf between us, despite the length of the letters being exchanged, I do not think the gulf is not able to be breached. I think we can bridge that gap. We did it on refresher fees literally by the Wednesday of the week after I met them. That's how quickly it happened. So there's no reluctance on my part. But nobody's going to benefit from that till they're back at work, because that's about Crown Court appearance. So, you know, we've got that in the bag. My problem now is, does that unravel? Because this has been the history of this relationship. That you think you've got pinned down exactly what people want, you deliver it, and then it unravels. I want to get back to the table, and that's where my officials will be this afternoon. I want to bottom out. We now know what the issues are. I think we got a really clear steer on that when I met with them on the 15th of January. And what I want to do is de-escalate this and get it resolved. I didn't say anything after I made the offer. I didn't disclose the nature of it. I didn't talk about it publicly. I didn't say anything about it. I let it sit with them to go and talk to their members and see if we can move it through. And look, at the end of the day, I could raise frustrations about the language that's used about my department, about the insinuation that the department are dragging its heels or lethargic in their responses. I could take issue with that. But look, that's not what this is about. It's about the victims. And it's about people suffering, and it's about getting to a place where we have open, transparent payments, and where people in legal aid get the service that they are paying for, albeit with public money, and that we know we're getting value for money, and also where it is within our gift supporting the profession in terms of its future sustainability. That is all we want to achieve, and I will be back dealing with the CBA and others again in the near future, because for me that is a goal that is too precious to be thrown away because we've had a setback this month. We've got to just keep going.
Good stuff. If I could just one more question, sorry, and it's just around. As I know you're bringing forward the sentencing bill, but there's been some concern around the lack of inclusion of misogyny as a hate crime and the definition of sectarianism, and I suppose the rise in hate crimes, and particularly those two aspects. And we see the crisis that we have of violence against women and girls. We know that misogyny is the cause of that. What's the rationale for exclusion there?
So the phase 1 consultation didn't include those issues because they covered areas that are legally more complex and I would argue politically more challenging. So the initial work that was done in the phase 1 consultation covered those other aspects. There was another part of Judge Marinen's review which related to what I would argue are more public order type offences, so things around hate speech, things around hate displays, and so on and so forth. And many of you will recall there have been a number of attempts to try to resolve these issues politically that have not been successful to date. That doesn't mean I don't believe it is possible to resolve them, but it does mean that I think it needs to be done in slower time, and we didn't have that time because of the fractured mandate. So what we did was we consulted on phase 1, and that's what we're bringing forward. It's not even all of phase 1 that we're bringing forward at this stage, because obviously with the shortened mandate we're only bringing forward 2 two elements, the aggravator model and the special measures for victims and witnesses in court. The issue of misogyny, as you know, has been raised in Scotland, and actually I think we had Helena Casey, Helena Kennedy came and briefed the Assembly actually at one point on this, and her view was that this doesn't sit well in a hate crime construct, that actually what is required is a separate piece of legislation around misogyny. And that's what Scotland have been exploring as part of the work they're doing. The difficulty is because most legislation tends to be gender neutral. How you would frame misogyny within the bill would become very complicated. And it could also, if it's not done properly, dilute what we mean by hate crime, because everybody would be able to identify themselves as something in the bill, so therefore everybody would be a victim of a hate crime potentially. So it's about how it's handled as opposed to whether or not it needs to be done. Scotland are looking at the model, and we would be interested to see the outworkings of that around doing something specifically around misogyny. The issue around sectarianism, there is, believe it or not, no official definition of what sectarianism is. It's one of those things, we all know what it is. We know it when we see it, but actually defining it is really complicated. For some people, it is about their religious identity. For others, it's not about a religious identity, it's a cultural identity. For others, it's a political identity. And for most people, it's an amalgam of all of those things. But trying to define it in law is really complicated, as Scotland have found out, and they're actually repealing some of their sectarianism provisions because they lack sufficient clarity, I think, in terms of what it is. Now, what we could do, I suppose you could include, and I think some others have potentially thought about this in the past, you could simply say that sectarianism is a protected characteristic and leave it to the judiciary and the courts to, if you like, fill in the gaps of what that means and what it looks like. But I think that's quite a lot to ask. I don't really think we should defer making legislation and policy to the courts. I think we need to do that. So that's a conversation that needs to be had. Part of the reason I'm not consulting on that, phase 2, we were to go ahead with phase 2, is I don't have the resources to both drive forward the phase 1 elements of the bill in this mandate and do the phase 2 consultation. So the phase 2 consultation will happen, but it will happen probably in the next mandate once we have the resource. It is the same people who would be doing that consultation that also did the consultation on deep fakes, that are also driving forward the 3 pieces of legislation. You will see it when they come here, you know, Mr. Chairman, it's the same officials. There just isn't the capacity to run another large-scale consultation, and it's likely to be one it's quite lively, I would suggest. So I think from our perspective in this mandate, given the time and resources we have, prioritising getting those areas we've already consulted on and have a substantive evidence base was the priority.
Okay, thank you. Thank you, Emma, Deputy Chair. Members, I'm going to just remind you that we're going to try and get everybody in. Minister, everybody wants to ask a question, so I would remind members to be concise, and Minister would remind you to be concise in your answering.
I will do.
Patsy?
Okay, thanks very much, and thank you, Minister, for outlining a number of issues there. Could I just take you, we've obviously all been provided with a letter here that the Chair referred to from the Criminal Bar Association, or from the Bar Association. Can you just confirm, please, that you issued a letter on the 16th of January to describe the review and with some key milestone dates? And of course, we're all on the one page here about victims, and we've heard some of the cases on the radio and in the media, and they're heartbreaking, and we want to arrive at the point of having those cases move on, and at least people attempt to get justice for what has happened to them. But I'll just read out what it says here, that the time from, you can correct whether this is right or wrong, or maybe not properly phrased, no later than the 23rd of January, the scope of review agreed with all parties. Review leads, CBA, Solicitors, Criminal Bar Association and DOJ, that's the 23rd of January. No later than the 30th of January, terms of reference agreed and review commences. No later than the 20th of March, report with findings and recommendations submitted. Now, we all know, we're all politicians, we know that the only way forward in these matters is dialogue. Mm-hmm. So, can you give any sort of commitment here as to how those dates have adjusted and how they may be complied with in light of some of the delays, and I recognise that it's hard enough to get a specialist consultant at the drop of a hat to deal with these issues, but can you give some indication as to how those dates might be fulfilled, so that at least in the public interest, and I'm sure the message will be going out to the barristers, look, if you guys want to engage in dialogue, we are genuine in our commitment to meet the framework for this dialogue and those deadlines for the dialogue. It may be adjusted, it may have slipped somewhat because of external factors which you had no control over, but if we had some sort of commitment around that, that at least we could see or a situation where dialogue could recommence and people get back in with a genuine commitment to fulfilling what we need as an outcome here in the interest of everybody.
So we met on the 15th and I put a proposal to the CBA. I then wrote on the 16th in the terms that you have described, and also to the Law Society, SCBA, the Bar and the CBA. The 23rd was the date when we hoped to know the scope. Mm-hmm. That required us to get, first of all, correspondence from the CBA to agree with the things that we had discussed verbally would be in scope, and also correspondence from the solicitors. And I think we got that around 5:15 on the 23rd, on the evening of the 23rd, which is a Friday. So we weren't in a position to issue the letter immediately to say this is the scope, but we wrote the following week to say that this was the scope.
That bit's dealt with.
Okay, so that's dealt with. The second part was that a week later, the intention was that we would agree the joint heads, and that's where I said it was difficult for us to get somebody willing to take on the work. We had no difficulty with His Honour Judge Burgess, who I have to say has the patience of a saint with this process, and he was willing to step in and do one of the chairs, which was again what was discussed. And then we had tried to get through SIB and indeed through external consultants, and you can keep me right on this, Hugh. We had tried to get someone. We got someone. Okay, so that has all been done as we sit here. So as we sit here, that has been done, and that was done, probably that was in the bag already quite a while back.
Certainly last week.
Last
in terms
week.
of getting the final update on the consultant.
The issue is that there was no agreement from the CBA to honour their side of that offer. So what you read was my side of the offer.
Yes.
What I was requesting from them in response was that they would return to deal with complex cases, rape, murder, and those cases as they had prior to the full withdrawal of service, at the point where the terms of reference were agreed. They said no. And then to return to full service at the point where the accelerated review was to start. And they said no. What they said instead was that if we proceeded with the review, they would consider possible further derogations on cases.
Right.
Which, as I explained earlier, wasn't acceptable.
So can I just take you back, there's a wee bit blank there for me, take you back there to the terms of reference being agreed. Are you giving us to understand then that the terms of reference were issued and shared with the Criminal Bar Association, and they didn't agree those terms of reference?
Well, the terms of reference, well, first of all, the scope.
Yes.
We had what
that.
was in scope. That was the first point that was to be agreed. The second was the terms of reference, but the bar indicated they wouldn't go back to full service until the end of the process. And that it was contingent. They intervened at that point and said they wouldn't go back to full service until the point where not just they'd reported, but that I had accepted in full whatever was proposed.
Right, can I just get back there? This maybe I have an all day, Minister. So did the Criminal Bar Association respond to you to say we reject the terms of reference?
They responded to say that because of the delay in the start of the review and the slippage, they were no longer willing to. They didn't wish to proceed and that they weren't going to restore service. That's...
Forgive me, are you reading this from the circular that's just arrived this morning?
I'm trying to establish there was a term of reference or terms of reference, right? They were sent out to the Criminal Bar Association, I presume, shared with them, to say, what do you guys think of these? How do they fulfil or meet your standards, or whatever phraseology was used? So what I'm trying to get in my mind is...
Well, the terms of reference ultimately were going to have to be agreed between the joint chairs and the department and the other parties. So yes. The process never started, is what I'm telling you. So we didn't get to the point of actually drafting a set of terms of reference because the CBA indicated they weren't willing to return to full service until the end of the process. The whole purpose of the process was to get them to return sooner rather than later.
So they were never asked, along with the other key stakeholders, what they felt about the terms of reference. That's what I'm trying to get at.
The terms of reference would be agreed collectively, Patsy.
Correct.
So you can't agree it collectively if people have said they're not engaging.
But
the letter that I wrote on the 16th set out clearly the conditions on which this would go ahead. They indicated that they will not accept the conditions. So there was no point at which they sat down with the joint leads to discuss the terms of reference. That would have been the next stage. But they've already said they won't accept the basis on which this accelerated process was being taken forward.
Just to get it clear, so at no point were they or their other stakeholders privy to or got sight of what those terms of reference or potential terms of reference would be.
I'm genuinely at a loss to understand what the question is, Chair.
Well, it's pretty clear from my point of view. They never got the terms of reference.
The terms of reference weren't something that I was going to impose. The terms of reference were to be agreed with the partners and the joint leads.
Yes.
But the process ended because the conditions attached to this meant that they would have had to return to work for that to happen. So they didn't.
And was that agreed by them?
That was the basis of the offer I put to them. It was not agreed by them. That's what I'm telling you.
That's okay. That's okay. I understand that now. I'm getting somewhere. Now, finally, then the report with the findings and recommendations submitted. Obviously, if you didn't move beyond stage 2, you wouldn't have a projected date to comply with then for production of a report. Was that included in the suggested TOR?
No, there were no suggested term. I'm not, Chair, I'm struggling. I've said there were no terms of reference produced. Yeah. There were no suggested terms of reference.
Agreed.
There was an offer made to the CBA. That offer was a staged offer with dates attached. I explained the slippage in those dates. Because of that, there was no engagement on the terms of reference with the CBA or with the SCBA or with the department or with the heads, because they said they were not willing to return to full service till the process concluded, and we said that was not acceptable to us.
So it was, forgive me if I may help as well, it was a process which we foresaw, if it had gone on the way it had, according to some of those dates, could have been concluded by March.
Yes.
So and part of the conditioning in going into the process to begin with was that there would be a return to work on a phased basis. So it's quite right that if that process had flowed, then we would, by the end of March, have been in a position where there could have been recommendations coming out of that review.
I have to say, I'm at a loss that you had a blank sheet in terms of reference. I'm at a loss to comprehend that, but maybe if we could move on then, please.
Could I ask in what sense? It's confusing.
Well, if you could give me a flavour of what the departmental thinking was, Naomi, that's what I'm trying to get at.
Well, first of all, when it comes to things like terms of reference, it wouldn't be for me to negotiate those in the committee, with all due respect. That would have been a matter that would have been dealt with by the joint heads. The purpose of not imposing terms of reference on this from the department was to ensure that there was no suggestion that we were setting terms of reference in a framework that would disadvantage any of the professions. So it would have gone to the joint heads to draft terms of reference and get agreement from all sides with their input as to what would be agreed. So it wasn't for us to come forward with terms of reference to impose on everyone else. That would have immediately undermined the process. We were trying to work collectively. We would obviously find the joint heads that would have to be agreed by all of those around the table. They would talk to us about what the terms of reference were going to be. The scope, we could agree, because we had had letters from the SCBA and the CBS to what was in scope. One of the things that was in scope was actually refresher fee pilot, and it ended up, we took it out of the scope because we solved it first, and we were able to do that in a short time. So I think it's the process perhaps that is causing the confusion. The bottom line is, if people had worked with us, and I accept, and I've been open and said there was slippage on the dates, but if people had stayed on board and been willing to work with us, I still believe that by March this year we would have concluded that review and had a report to the department with recommendations. And I think that we would be in a much better position had that been able to move forward. I mean, as I said at the beginning, I'm not going to rebut line by line what has been written by the CBA, because I have only been cited on it in the hour before I came to committee, and I had a number of other things to deal with. We will go through it, obviously, and look at it, but not, I have to say, to engage in a tit-for-tat retribution and slanging match. In some ways, what is water under the bridge is water under the bridge. What matters now is where we go from here, and that's what my officials are focused on this afternoon at their meeting. That's what I'm focused at when I go back in, because with respect, there will always be those who will want to shift blame elsewhere. All I can do is my best in this situation. I want to put that behind us. That didn't work. It was an offer. It didn't pan out. And now we have to look at something else that we can do that will potentially bring the CBA back to the table in a way that will allow us to conclude and get them back to full service.
Here, just for absolute clarity, I know how the process works. All I was trying to get was where the department was coming from, just to inform myself on what your response would be to the TOR. And it will have to be agreed. Been there often enough, and you've been there often enough in other places to ascertain how TORs work. Just one final brief question, and that's around the proposed reform of legal aid costs. Just one question in regard to that. Can you, Minister, outline how you intend to safeguard the independence of that process and reassure the committee that these reforms won't result in the department effectively marking its own homework?
I'm unaware as to where the department would be marking its own homework in that process.
In relation to the independent taxing master who has already had a statutory role to do that.
So the issue of the taxing master has been raised by the Northern Ireland Audit Office and the PAC on a number of occasions, because particularly for cases where you're dealing with appeals cases, you're in a situation where it is a process that is opaque. It doesn't allow us to prove value for money or to demonstrate openness and transparency. So that has been on for reform for some time. The taxing master role, under the review that we have done, will still exist. So the taxing master will still make those decisions, but it will be within rates that are set. So they will apply rates that are set by the department, and that gives the openness and transparency. It ensures that they have the understanding of the cases and how they run, and will be able to make proper decisions about what is valid claim and what is not a valid claim. That remains an independent judicial function. The only thing that the department will be doing is setting the rates which can be applied in the various cases.
That's quite helpful, but I'm loath to get into the taxing master
No, that's
stuff.
okay. I'm happy enough.
We're doing that through
Really
Justice Bill.
I'm loath to as well, because it is.
But your clarification is quite helpful, Minister, because we were debating that before you came in.
But there will definitely be a taxing master at the end of this process.
Yes,
We're not
okay.
eliminating the
Right.
function.
So we are struggling for time. So I'm going to add Connie.
Yeah, Chair, can I just ask a question, if you don't mind, procedurally?
Yeah.
This letter that's been referenced throughout this process, was that circulated by the clerks or the committee?
No, it came to us all individually. I know that myself and Brian received a copy. I don't know who else, but going by the questions, I think most people have
Right.
had.
That's interesting. Just sorry, I feel a bit on the back foot here. I didn't receive that.
Okay. We received it yesterday.
I'll send it to Connie, see if you've got it.
Yeah,
you.
yeah.
You received it?
I think it was yesterday.
Last
night.
Yeah, late last night.
That's interesting for those of you who are concerned about delay, that we received it at 1 o'clock today.
Okay.
Apologies, Chair. I didn't know if that was something that should have been in our table pack, or I'd missed it by the committee clerk. So
Hear you.
apologies.
And I know you read every line in your pack, so Connie.
They are extensive packs. Thank you, Minister. If you don't mind, there are some other issues I would like to ask you about, and thank you for coming before committee. Could you outline just any policy areas that you haven't been able to progress due to blockage or obstruction at the executive?
There are a few areas I think where there have been challenges, and as always, I have to navigate this carefully. So, for example, I mentioned earlier the repeal of vagrancy laws is something that we had hoped to bring forward as part of the Justice Bill, and we were not able to get approval at executive level for that. It wasn't a final no. I would have to say it was more a qualified not now. And I would still, as I say, be very keen for the committee to look at the issue of vagrancy, because I believe the committee, rather than the executive, is the right place for these discussions to take place, for you to scrutinise the detail of what actually will be left when you repeal the vagrancy laws, what other measures the police will have to deal with antisocial behaviour and other things. So that's one area. The other area, I suppose, which it's unclear, frankly, where we're at the moment. So I wrote to colleagues a while back and asked about the addition of transgender as a category for protection under hate crime. I received 3 positive responses within the deadline set, and so we issued instructions to OLC to say that we did follow up on the correspondence, but we went back and said to OLC that we would go ahead and draft on that basis, and then subsequent to that I have received a negative response, so that will come drafted for inclusion in the sentencing bill, and then it will be a matter for executive to make a decision as to whether or not it remains in the bill as introduced.
Thank you. Can you outline then for us how important do you think it is that other departments have a role in the justice system? I think I was at an event earlier this week in the Long Gallery, and the Commissioner for Victims of Crime had really advocated for more funding into justice, because it's about our whole society and how safe it is. So how important do you think other departments have a role in keeping our society safe, reducing reoffending, and we often hear about how failings elsewhere end up in the justice system?
I think there are a number of layers to this. I think first and foremost, a lot of the people who end up in the justice system end up there as a result of often having fallen through multiple safety nets in other parts of provision, whether that's mental health, whether it's education, whether it's kind of youth work gaps and other things. So I think there is a real issue there in terms of the pressure that puts on the department. It's something that PSNI feel acutely when it comes to interventions in crises where the primary intervention is not necessarily a crime. So 8 out of 10 calls to the PSNI don't involve report of a crime, but actually of a crisis. And those are not always policing matters, but the police will obviously always respond where there is a risk to life. But that can consume huge amounts of their time, not just in the initial intervention, but often accompanying people to hospital and other things, and then waiting with them while they pass through the system and get treatment. So yes, I mean there are pressures that arise from filling those gaps. There are also areas where we don't have the varies to do the things which need to be done in order, for example, to ensure that we effectively tackle reoffending and assistance in the community. So we know that the factors that affect that will be employment, family connection, good health, particularly mental health, and accommodation. Most of those fall outside the justice system, and once somebody leaves prison, they are no longer subject to our department's rules and regulations, but there does need to be suitable accommodation, often supported accommodation for those who are more vulnerable, and as I say, so it becomes more complex. So we have been doing, through the reduce and reoffending work, and you may want to say something about that, we have actually as an executive prioritised this as a piece of work as of the department, and we have had some, I think, quite positive engagement with officials from other departments about things like health, housing, and so on for those leaving the criminal justice system. In the same way, for victims, much of the care and support they will need will fall outside the justice system. It will fall to healthcare professionals and others. So we have a history of working well, I think, with other departments, but as budgets become more strained and as pressures increase, there is a tendency for people to turn in on themselves and their department and to try to hold what we have rather than pool our resources to be able to deliver better outcomes. And I think it's really important that we try to maintain the focus on that pooling of resources where we can potentially do more than perhaps our individual efforts would be able to deliver if we work collectively, collaboratively, and reinforce the work that's being done in other places. And you might want to say something, Hugh, about that at official level.
If I may, Chair, so we have been progressing with other departments, so you'll remember there's a commitment in the programme for government that we will have a reducing offending and reoffending strategy during this programme for government period. So we've been pushing quite hard on that with the other departments, and we've done quite a bit of work at all sorts of levels, and indeed with ALBs as well. It's been very promising. It's been very positive. All of the departments are very positively engaged with it. We've no problem there. The task will be first to create a framework out of that, which we can bring out and get wider public views on that and so on. But then to translate that as well into the actual strategic approach, which we still hope to do still intend to do by the end of the mandate. And it will be the kind of hard-edged bit where we'll need other departments and other participants to commit to what they are actually going to do to help change all of those criminogenic factors and reduce the likelihood of any individual coming into the system as a whole.
One more, Chair, if you don't mind. Thank you, Minister. I am concerned that you said budgetary pressures could be catastrophic for your department, and we know how squeezed it's been over the last number of years. Could you maybe speak a bit more to that, but also talk about, in that context, the transformation that DOJ has actually been able to deliver as well over the last decade?
Well, I think there have been huge changes in the justice system over the last decade. For example, if you look at prisons, 10 years ago, we were being told that our prisons were failing institutions. The most recent SIGINI inspections of prisons have given them, particularly take Hyde Bank Wood, for example, which was at that time a failing institution. We now have top scores across the board, so 4 4s. It doesn't get better than that in both the women's prison and in the young offenders area of it. So there has been massive transformation in terms of how we do business, in terms of the quality of what we do, and that's not something that I'm just saying here as Justice Minister. It's something that's recognised internationally. I mean, Hyde Bank has literally just won an international award for excellence in rehabilitation. So, I mean, these are things that very rarely get publicised but are hugely important in terms of just recognition of the huge amount of work that staff put into all of this. We have lots of work that we have done around youth justice, lots of work that we have done in terms of driving down the numbers of young people who are engaged in offending behaviour, and particularly those who end up in custody. And going further upstream and doing earlier interventions to try and deflect young people away from the justice system, all of which has been, I think, really positive. In terms of innovation in the department, again, we've seen that really take off. The challenge that we have had, particularly around tackling things like delay in the courts, which is an area in speeding up justice where we have been successful in our transformation bids, is that not all of that is in our gift. So it requires each part of the criminal justice system to buy in to that, to look at new processes, new procedures, different ways of working together, considering things like out-of-court disposals in order to save often what ends up being a fine at the end of a very long and expensive process, being able to be a fine at the start and cutting out all of that work in the interim. There's been a lot of work done in terms of how PSNI and PPS work with each other, and also then how PPS and the judiciary work together, and we continue to push that at the Criminal Justice Board. We've been successful in terms of the applications we have made to the Transformation Fund, and those bids are being applied. We are starting to see, or were starting to see, that bear some fruit. Things like the CBA strike risk undoing some of that progress around speeding up justice, but it is going to be challenging. In terms of the budget, I mean, just to say, when I say catastrophic, I don't use words like that often. I've said before it's incredibly challenging, it's very difficult. So I use the word catastrophic with a degree of seriousness and weight attached to it. I mean, if you look at the budget for a year for many of our critical ALBs, probation, courts, Youth Justice Agency, it would the savings that we would have, the pressures we would have, would exceed their entire budget. Okay, so given that around 65% of our overall finance will go to policing, and we're left with the remaining 35% to run everything else, and given that we are trying to stabilise and grow policing numbers, you can appreciate just how catastrophic that could be for the other parts of the justice system, and they are not less important than frontline policing, which is important. But prisons makes a massive contribution to public safety. Probation, essential and underrated and undervalued as a service generally by the public, but do incredible work in terms of turning people's lives around and changing behaviours and supporting people reintegrating into the community to desist from offending. Youth Justice Agency I've already mentioned, all of those absolutely critical, and it's very hard for me to see where I can find savings that will not do not just harm to programmes or initiatives, but actually to the infrastructure to deliver those services at this stage. And maybe Hugh, I mean, you're obviously very conscious as our accounting officer of how bleak this
I'm
looks.
conscious of time, Minister. So,
but I think it's important because everything else that we discuss here, this is it.
I can give you 60 seconds, Chair.
Yes, good man.
Richard Logan will be here in a while, but so out of the draft budget proposals, remember they're only draft budget proposals, the pressures we quantify just in stabilisation pressures for the 3 years of the period would be 100 million in the first year, 140 in the year after that, rising to 215 in the year after that. That's after the projected allocations which are in the budget. So remember, our resource budget is only 1.4 or thereabouts this year, and how difficult it has been to live within that, and it's only been done by a considerable amount of suppression of activity, considerable amount of holding vacancies, and indeed some assistance from Department of Finance and the Executive as a whole. Those pressures are coming up. They don't even take into account the exceptional pressures, as we know, of data breach, of McLeod, of holiday pay, which are coming at us coming to all departments to some degree, but we bear a particular share in that. Nor indeed does it take into account the Chief Constable's estimation of what he needs in relation to settling civil claims in the legacy space, which is another exceptional pressure there as well. So it will be if the draft budget proposals translate, it will be an incredibly difficult task for the justice system to operate in that, and the Minister's description of catastrophic is entirely right.
Okay, Doug.
Oh goodness, Minister, thank you for all the information you've given us. I want to talk about the life sentence order 2001. The court sets the minimum term for a prisoner. That's a retribution, the deterrent phase. But the prisoner has no right to be released after that tariff has expired. Instead, it goes to a risk assessment phase, and the only thing they look at is public protection. And the Patrols Commission can only direct release of an individual if there's no risk to the public, and that's signed off by the Secretary of State. But surely Rule 27 that we use for pre-release testing undermines that very principle, because we're letting people out before that tariff is finished, before the Parole Commission has said you're fit for release for public protection, and they're being released sometimes up to 48 hours unaccompanied without that coverage. Is there no way we can look at this to see how this sits?
It doesn't conflict. The two pieces of legislation are for different purposes. I think I've explained this in questions in the Assembly and also potentially in written answers to yourself. Pre-release testing, I think the benefits of that need to be recalled and remembered. It is considerable for the wider community. I do understand the concerns that people have about the idea of releasing prisoners, and on some occasion where they breach the conditions of that temporary release or go unlawfully at large as a result of pre-release testing, particularly where that happens on more than one occasion, and as you're aware, we're actually looking at that particular assessment process now. However, graduated release on a temporary basis does not equate to final release, which is what's covered by Article 6 of the Life Sentences Northern Ireland Order 2001. It says clearly in Rule 27, I think it is, that we can release people for a range of measures, one of which is rehabilitation, and that is the rule that is used to allow people to be released for short periods of either accompanied or unaccompanied pre-release testing during the period when they are serving their tariff. When they have served their tariff, they then have the right to apply to the Parole Commission to review whether or not they should be released, and the Parole Commission will then come and ask the department for evidence as to whether or not this person is fit to be released. And it is on the basis of pre-release testing that that report from Prison Service is able to be produced. If there is a breach of temporary release conditions, there is the authority, first of all, to immediately return the prisoner to custody. So there's no statutory formal recall required. If a person is released on life licence, there is a recall process and procedure that has to be followed. With Rule 27, they're simply returned immediately to custody. So there is no conflict or override between the 2001 order and the 1995 rules. One is a temporary release for a specific purpose, and the other is the final release on life licence and based on the decisions made by the courts.
Yes, but I guess the point that I'm making is the temporary release, even for 48 hours unaccompanied, and I'm focusing on the unaccompanied here, a temporary release unaccompanied is not with the direction of the Parole Commission or the Secretary of State to say they're safe to go out into the community. So nobody has made that declaration for them to go out into the community. And I'll give you a live example, and you know about this live example, and that is the Parole Commission got in touch with the family of Jim McFadden and told them that James Meehan would not be released. That means he's not being released because he's not safe to be released into society. 2 months later, he was released. Now, how is that not a conflict? I'm not talking about pre-release testing. I'm talking about the fact is that who has signed off to say this guy is not a threat to the community when he's allowed out unaccompanied? Not accompanied, I get that. And if you look at Rule 27, none of it is about making sure he's safe in the community. It's about re-establishing family ties, securing future employment, attending training, education, rehabilitation and reintegration. I'm talking about safety of the public here. None of those things.
Well, rehabilitation and reintegration successfully into the community are about public protection and about public safety. And the issue when a prisoner is released, and there will be prisoners who fail their pre-release testing. That happens. It is unfortunate. It's not the majority of prisoners, but it does happen. And when that happens, that will also form part of the report that is sent to the Parole Commissioner when they determine whether or not a person should be released on life licence. That is their final release on life licence. However, if the Parole Commissioners decide not to release somebody on final life licence, it does not eliminate the responsibility on Northern Ireland Prison Service to continue to prepare that person for their eventual release. So what I have looked at in terms of reform is how frequently around that hamster wheel prisoners should be allowed to go, given the impact on families, and that's something that we are reviewing, and I've also set out why. But we still have a duty to rehabilitate that person and to engage in a series of pre-release testing, some of which is within the prison in terms of them going through the regime and the progressive regime that exists within the prisons. Some of it is about assessments that will be made by those, for example, from probation who might be working with them within the prison system. They will then be released for short periods accompanied and then again unaccompanied at testing. And that has to continue. That will then potentially go back to the Parole Commissioners, who may or may not decide final release is required. But that is the process by which we determine whether or not someone is safe to be released. If someone is released for a short period of unaccompanied release from prison on those conditions, meet those conditions, return successfully, then the next stage may be that they're released for a slightly longer period of time. We try to measure the risk around, for example, people with a history of absconding, people who have broken their release conditions before, will be looked at more carefully and assessed. The idea that prison service are not capable of assessing the risks attendant to any prisoner, I think, is an insult, frankly, to prison officers who have to, on an ongoing basis, assess the risk attendant on prisoners while they are in custody, to keep themselves and other prisoners safe. That is their job, and rehabilitation and reintegration are valid reasons for short periods of temporary release. It is for the parole commissioners and only the parole commissioners to decide when somebody will leave on final release, and where somebody has a fixed custodial sentence, it will be for the sentencing judiciary. There is no conflict in this issue, and I am aware of cases, and I do not in any way diminish or disregard the stress that it causes to individual families of victims when someone is released and either absconds or are released when they were not expecting that would happen. But our statutory duty has to be met, and that is to provide the evidence to the parole commissioner so that they can make a determination whether or not that person should be released or not permanently.
If I can, Minister, I don't think there's anything wrong with standing up for victims here and promoting an issue that they're raising with us, because there's absolutely no reason whatsoever that you cannot do pre-release testing after the tariff ends, because it quite clearly states in the life sentence order the prisoner has no right to be released at the end of the tariff, and there is a risk assessment that needs to be done. Now, in the case of James Meehan, the risk assessment was he was still a risk to society, and yet we still released him. Now, for somebody to tell me that the people we empower, the Paroles Commission and the Secretary of State, who are the ones to say you are safe to go out, you are safe to go, the Secretary of State signs off on it,
No,
you are safe.
That's incorrect, actually. The Secretary of State in that now is me.
Okay, well then you sign off on it. But the bottom line is, if that's the people who sign off on it, and you're telling me that actually the prison service can say, actually no, they're not going to sign off on it, we're going to let them out. That is absolutely undermining it. And the issue of Thomas McEntee, at his trial, the judge, when sentencing him, said he is manipulative even when he seems that he is in a safe place. He will always be unsafe. And he was released, and the family weren't told. Well, so it's fair, Minister, that I raise this issue. I absolutely accept the point you're coming back with. I want to see people being able to release safely into society, but it's right and fair that I raise an issue that's being raised with me by victims when they see somebody who is being released when he shouldn't be released, and there was no requirement for me to be released. In this case, with James Meehan, after the Parole Commission said he shouldn't be released, and after Thomas McEntee, whenever the trial judge said he is danger all the time. Who signed off to say he's not a danger? You've said it's you.
No, I said that in the law, the issues that fell to the Secretary of State pre-devolution in the main now fall to the Department of Justice. Mr. Chair, I'm not sure there was a question in that, but I will do my best to answer as best I can. First of all, I never questioned Mr. Beattie's right to ask the question, nor did I question the impact that it had on victims, nor did I say that I discounted it. I was at pains to make clear that was not the case. In fact, I've initiated a review of how this works in practice to ensure that victims do not end up on this relentless hamster wheel where somebody gets closer and closer each time to release. Mr. Beattie again quotes the judge. The judge had it in his gift to set a higher tariff and opted not to do so. So, I mean, I can't comment on that. The judge made a decision as to what the tariff ought to be in that particular case, knowing full well that in approaching that tariff, there would have to be pre-release testing undertaken. It's a statutory duty of the department. The Parole Commissioner judgment is a different one from the Department of Justice and the prisons assessment. The Parole Commissioner is deciding whether somebody can be released on life licence and essentially would have to commit another crime or offence or be judged by their supervising officer where those are supervised cases to be conducting themselves in a way that would require them to be brought back to prison. And if they're a life licence prisoner, I have to sign that. So yes, it is me that signs to recall the prisoner. Okay? And I do that in the recommendation of the Parole Commissioners. That is the decision that they make. Now, I don't decide who's released. I do decide whether I'll sign off on the recall on their advice. And that's what the law actually says. So if you look at the issue of individuals, and I'm loath to get into individual cases because I recognise the potential pitfalls of that, and even prisoners, and particularly families, I think have a right to some privacy. I think it's important to say that what prison service are doing through testing is not release. It is a temporary release for a particular purpose. They are not saying that this individual is free to walk free, go where they want, do what they want with no conditions, which, by the way, is not what happens. They are saying that under their statutory duty to test this person, that this is what they should do. And with respect, I have set out very clearly what the statutory duties are. I have answered these questions, I think, with courtesy and respect. And I have done so in a way that recognises the impact on victims. Perhaps before this session closes, Mr Beattie would take the opportunity to apologise to my officials for the erroneous narrative that he peddled yesterday and for the outrageous things that he said yesterday on the state of my department and my officials' performance. Because, with respect, Mr Chair, I am more than able for political knockabout in these sessions. I am more than able to take my stripes as Justice Minister and as a politician. But what I will not do is have people drag my department and my officials who work hard to keep this place safe through the mud in order to score cheap political points.
Okay, Minister. Doug, do you want to come in? I'm going to just briefly now, because we have...
I will, and very briefly, if I can, on this. I mean, you can deflect all you want, Minister. The bottom line is this. Your department is releasing prisoners into the community who have not been tested fully and they are not safe. That's the reality to it. You know it, and you haven't answered the question I have raised on multiple occasions. That is, why did the Parole Commission say that James Meehan should not have been released and he was a danger to society, and yet he was released for 2 days and then absconded down south? But if I can, very, very briefly, because I think victims are really important, and I'm really tired of them being ignored. I raised an issue with Hugh when he was in the last time. I thought it was a good question. I thought he gave a good answer. But we have various victims and care units which deal with various different things, and I can fully understand that. But people are falling through the gaps. I've raised this question with you before. Maybe it's time that we have a single victims and witnesses care unit, so nobody falls through the gaps, and that we go back to an opt-out system for the victims information scheme instead of the opt-in system, because people are missing information, which is key. And recently, I know of one family who had a family member murdered, and they just found out that the murderer was arrested in Portugal. And they didn't find it out through the victims' care unit. They found it out in the newspaper. Not your fault, but I'm just making the point that people are falling through the gaps.
If I may try to answer those points. First of all, I note that you haven't apologised to my officials. Secondly, when people, you want people to be fully tested, but you don't want us to test them, I think you need to work through that conundrum in your own head before you raise it with us again. Because in order to fully test people and judge whether or not they're safe for release, that requires us to do staged testing. And that is how we reach that.
Doesn't do
Excuse me.
Rule 27 doesn't do that.
I'll let the Minister speak and then we'll move on.
Mr Beattie has had quite a while to harangue us here, so it would be good to be able to answer. When it comes to people being fully tested, that requires us to do that in a progressive way, and we do. And it is measured, and they are risk assessed by those who are working with them in the prison. To suggest they are not risk assessed before release is a nonsense. Secondly, in terms of the Victims Information Scheme, there are good reasons why the Victim Information Scheme is opt-in and not opt-out. Because many victims, understandably, do not want any further contact with the justice system post a conviction. They do not want to know anything about the person who was convicted of a crime against them. They find such contact re-traumatising. So it is important that we don't presume that they want that. What many victims find is that as a victim of crime, the agency that they have as an individual is taken from them, and that they are deprived of choice in those situations. And what we are doing by having an opt-in system is fully informing people of the scheme that exists, of how it will work, of the contact that they can expect from that system, and then allowing them to have the agency to decide whether they want to know or not to know, and to be able to exercise that choice at any time. So some people may not want to sign up immediately, others may decide to sign up later, some will sign up immediately and then decide they don't want to know any longer and withdraw, and that is acceptable. There are failings in that system. So I have held my hands up and apologised to victims whose names were not properly connected to the individual perpetrator, and so were not actually notified when a perpetrator was released. And that is, or was being considered for parole, I believe, so they weren't able to make the suitable representations. And we are addressing that. We're also looking at the wider system to see how we can minimise the risk of that happening again. There is no system which is perfect. There is no system. Human error will always be a factor in every system. What we are trying to do is make the system robust, transparent, effective and victim-centred. With respect, given the amount of time that I dedicate to meeting victims, to working with victims, to promoting protection for victims in the justice system, I need lectures from no one about the importance of being sensitive and trauma-informed in our practice when it comes to victims. Do all of our justice partners and all of the people in the department get it right on every occasion? Absolutely not, which is why my door is open to listen to the experience of victims, the lived experience, not the experience that I would expect given where I have directed that things should happen, but what it actually means for them in practice. I understand the point that's made around having just a single victim centre that would deal with it all. And I understand where that comes from. However, people need different forms of support at different points in the criminal justice journey. Victims and witnesses care, for example, within PPS, do a very specific job, which is about guiding those who are going through the justice system and who need very particular support to understand that justice system. In the same way that sexual offences legal advisors are able to give very tailored legal advice to people who are going through the court system. Many victims who report serious crime will not decide to go to court, and therefore we have victim support, which offers people, irrespective of whether they decide to embark on a criminal justice journey, the ability to be able to seek support as a victim and the proper care. There will also be things like, for example, the system which allows victims to be updated on progress with life licence prisoners and other things, and that is also there, and we are trying to make that more robust and put more fail-safes in place. But that is the reason why there is not a one-size-fits-all. So there will be people who at different stages will need different support. From the very first point where they make contact with the PSNI and they know who the officer that they should be contacting is, right through the system, where they might have specialist support from people like Nexus and others, where they might have specialist support from Women's Aid, right through to victims and witnesses care unit who will prepare them for trial and support them through that journey. So it isn't a one-size-fits-all. It has to be tailored and dedicated to the individual victim at that point in their journey. Okay. And to finish, I have not berated anybody for raising victims' issues, nor would I ever. But I do, Mr. Speaker or Mr. Chairman, I do object to the constant tone of negativity around these issues and the unwillingness to accept the factual evidence that's presented. I am willing to look again at issues where there are matters of substance being raised and where I believe processes can be improved. I have never deflected from that journey, and neither have my officials.
Okay, thank you. Aoife?
Thank you.
Who I'm sure will not harangue the Minister.
We'll see.
Look, I thank you for your answers so far and for the briefing today. Mine's going to be in and around the family court system. And look, we have seen time and again, and certainly I have had women in particular who have come to me saying how re-traumatising the court system can be, particularly in terms when the abuser uses that as a form of continuing their abuse, whether it be coercive control, financial abuse, and taking that victim back time and time again, and being allowed to be taken back time and time again to the courts. And the courts failing, I suppose, to recognise a pattern of behaviour. And I do understand that there is protections in place that can stop that from happening, but they are very rarely, in cases that I have heard, enacted. So I was very lucky then to go to that recent research launch from the Victims of Crime Commissioner, and it outlined the family courts are being used as a form of abuse from the abusers. And so what plans have you got to take on their recommendations?
Well, a couple of things about this, and I'm really well aware of it, particularly around the work we did in the last mandate around domestic abuse. And this is something that we are aware of, that those patterns of abusive behaviours will extend beyond the end of a relationship. They will often be pursued around contact of children and other things, and so we are aware of that. In terms of the specifics around people being recalled to court constantly, that is something that a judge has to make a determination on whether this is vexatious, whether it's substantive. That's not something that the department can really guard against, because to do so would require us interfering with the individual parental rights of all parents that would prevent them going back to court. What the threshold is for returning to court, again, is something that will be judged by the judiciary when somebody makes that application. Judges can, of course, decide that one particular party to the case is being vexatious and can take action in that regard, but that isn't something that the department would be able to deal with. What we were, however, keen to do was ensure that people were not, for example, abusing the legal aid process to do that. So we had examples of people who, you know, their partner gave up work, got legal aid, were using the court process repeatedly and vexatiously, and then we were in a situation where their partner couldn't afford representation, and then were being cross-examined, for example, by their former partner who was an abuser. So what we did was we introduced, there's a domestic abuse waiver within the system, so it's not based on means testing. The means testing can be waived, and that is available to people where they are the respondent in a case in the family courts, so that people who initiate the contact don't get the domestic abuse waiver, but people who are being called back to the court, and that was an attempt to do that. What we've heard from the professions as part of the work we're doing is that actually it's quite complex to navigate, and so one of the things we're doing as part of the Enabling Access to Justice process is to simplify the application of the waiver, to make it more attractive for solicitors to offer to their clients as an option in terms of getting advice. The complication with the family court system is that the policy does not rest with the Department of Justice. So without wanting to sound trivial about it, we provide the buildings and the seats and everything else, but the policy rests with the Department of Health and the Department of Finance. So, for example, marriage law does not lie with us. It lies with the Department of Finance. Family law doesn't lie with us. It mainly lies with the Department of Finance or the Department of Health. So things like child contact, social worker reports and so on all lie with the Department of Health. And the policy around this lies with the Department of Health. However, nobody seems that willing to grasp the nettle. So what we have done is with the work that has been happening, obviously, with the domestic abuse or the victims commissioners work on domestic abuse, we're actually convening a round table of officials from different departments to try to look at what we can do better in terms of the family courts. I have already given some examples of things we have tried to do to mitigate some of the challenges in the family courts where it does lie with the Department of Justice, because I do recognise it as an issue. For example, the use of children as a means of abuse or coercive control is recognised in the Domestic Abuse and Civil Proceedings Act, and that is an aggravator as well for the offences. So we have made provision where we can in that space, but the actual detail of the family courts is essentially judicial led, based on policy from two other departments, and our role, as much as anything, is to provide them with the court space and court services that wrap around it, rather than actually to deliver on policy change. But I recognise that there's a huge overlap between the people that I meet as victims of domestic abuse and the people that I deal with who are concerned about the family courts. And so rather than sit back and let it fester, we want to take it forward and try and convene, I think, hopefully something that will be useful in terms of looking at how do we do this better. And how do we improve it? There's also a judicial-led initiative by the Lady Chief Justice, I think, around the family court system. And there are some things that I think wouldn't require new legislation, but maybe just a change of approach that could be quite useful. But I know that the Lady Chief Justice is is interested in the issue. She actually served for many years as a judge in the family courts.
We had a briefing from her very recently, a number of weeks back, and she is due to share her research piece with us, and it was actually, I suppose, a breath of fresh air to hear some of her take on the family courts, and given her history, it's very evident to see that she knows the issues that lay within the family courts. I suppose in terms of, I understand that some of it doesn't lay with you, but I do think that knowing the family court system, it's a very unfortunate place, particularly for women to find themselves they're cross-examined at a time and are supposed to be able to answer questions and to come across as, I suppose, supposed to come across, she's being judged on her parenting, she's been judged on any decision, and that is by the perpetrator taking forward her case with perhaps accusations that are unfounded. And I think when that happens time and time again, we have to recognise that as a pattern of behaviour from the perpetrator. What I suppose my question is, what is there any training, if any, available for those who work in the court system to recognise those patterns of behaviour? And particularly in one case, and just very quickly, I seen a case where 1 week there was a non-molestation order for 9 months granted to a perpetrator, and that obviously, as we know, a non-molestation order is for no direct or indirect contact. That same week later, that lady sat in court and was cross-examined in the presence of the perpetrator, and I just find that mind-boggling that can be the case. So is there training available in those instances to say this is a victim of domestic violence? And I suppose that you did mention that there is legal aid for domestic violence, and I'm glad that you have said that it's a very, very difficult system to go through. Solicitors are coming back to us, particularly me, saying, I need to be an accountant to do this, actually. So,
well, we are
Yes.
going to simplify that, particularly around the waiver. We also want to expand the number of people as part of that who are eligible for legal aid under the means test, because at the moment the means test threshold means that the majority of people, even if they are kind of in work but not necessarily earning a lot of money, still would not be able to access legal aid, and we want to change that. In terms of training, judicial standards and training are again a matter for the Lady Chief Justice, and they will work through a variety of training. I know that they have done training on a number of issues. I mean, for example, recently the LCJ issued a circular to judges to say that, for example, the issue of parental alienation was not recognised in the Northern Ireland courts, and she issued a clear guidance around that. There is also the issue then, as I say, of judicial training, but you understand that those aren't issues for the department. Those would be issues that would come forward from the LCJ. We obviously share information or resources that we would use in terms of our own internal training. And we would pass those on to the LCJ and to the wider judiciary, so that they have access to those where they feel that those are appropriate and helpful. And we'd be more than happy, obviously, to raise this as well in the context of potential plans for training of judges in the future. I know that there had been some discussion, I think, during Judge Gillen's review, where Sir John Gillen had suggested that there may need to be, given the complexities of sexual abuse, domestic violence and so on, kind of specialisms almost for people. But that again is something that would fall to the judiciary to consider.
The mandate, the last mandate, had seen lots of positive change surrounding coercive control, stalk and strangulation, etc. And it seems some of this work has slowed down, particularly on introducing domestic abuse protection orders and notices. When will we see these introduced?
Well, the issue of domestic abuse protection notices and orders is a complex one. First of all, in the last mandate, those were added to the legislation by the committee in terms of putting a deadline on when they had to be done. We had advised against it on the basis that operational partners needed to bottom out how they would operate and how effective they would be in the Northern Ireland context, and also there was no clear path for us to obtain the resources that we would require to actually make the system operable. We were also aware at the time that whilst they had been introduced in Scotland, they were not operating successfully. And so what we have done now is look to a pilot, look to a pilot approach, first of all, to scope demand, and then build the evidence base in a Northern Ireland context so that we know that the model that we adopt will be operationally sound, but also will bring additionality over, for example, a non-molestation order, a stalking prevention order, or whatever it might be. So what we're trying to find out is how we can do that. It's our wider commitment, obviously, in terms of responding to domestic abuse and violence against women and girls. It isn't that the work has slowed down, the work has continued at pace. It is that it is very complex work and was never going to be able to be completed in 2 years. And actually in the 2 years that we had, the executive wasn't here for most of it, so we couldn't even progress it in that space. Obviously we want to get this right. I do not want to offer the veneer of some additional protections when actually they're only on paper and they're not effective. So what we're trying to do is learn from experience elsewhere. So we've gone and looked at pilots that are running in England and Wales at the moment. And we're trying to look then at a tailored model that will work in Northern Ireland. In fact, I was just speaking to ACC Beck in the last few days about some of the things PSNI would find helpful in terms of making these potentially useful to them and to the courts, which is of course one of the things that we're wanting. At the moment, they are police-led. So it removes the requirement on victims to make application. But obviously one of the things that we would want to consider is whether or not a judge should also have the right to apply one at the end of a court case, whether there's a conviction or indeed whether there's an acquittal. The judge may feel there is enough evidence to justify a civil order to protect a person who they feel is still at risk even though the initial case couldn't be proven. So those are some of the issues that we're looking at the moment. In terms of the pilot, it will, I have to say, depend on resources. We have invested significantly in scoping that pilot this year. We have also applied, I think, through transformation.
We've a
funding.
bid in for the transformation fund, current round. We reckon it would cost them the next 6 or 7 million over 24 months for the pilot, but we haven't yet heard back about the results of that. Application into the fund.
But without that, we will still try to proceed, but it will be potentially at a much slower pace. Again, it will be the same people who are looking to all of the other things in this sector and bringing these forward. I'm confident that what we have now is, I think, a workable pilot in terms of what that would look like. And if we're successful with the transformation bid, I would be hopeful that we would see that happen sooner rather than later. But as I say, given the pressure all operational partners in this space will be under, without that additional resource, it will be very difficult to deliver.
Okay.
Yeah, go ahead. That's
okay. Brian?
Thank you, Chair. I'll try and keep my questions brief. Minister, you've already spoken about the barristers' legal aid strike at length. And you said earlier that CBA rejected your proposals, but you also said the gap is not great. Mm-hmm. Is it fair to say the current situation is down to a bit of a standoff over whether they should be returning partially or fully at the time of the accelerated review?
No, it's whether they would return at all during the period of the review, even partially.
Said they will recommend returning partially?
No.
A graduated response?
No, what they've said is that they would potentially consider some additional derogations, which would mean that a committee within the criminal bar would decide which individual cases make it to court. Mm-hmm. And they've only said they would potentially consider that. They haven't committed to it. So that is quite a stretch away from where we wanted to be, which was partial return, so a reversal to the pre-January situation where they would only withdraw from complex cases, and then as the review progressed, that we go back to full service. So that's the issue. The gap that I was speaking of, just to be clear, Brian, was the gap between the gap between us on the substantive issues in dispute. You know, I mean, I've used the refresher fee pilot as an example, but we came up with a solution to the refresher fee pilot last August. It was rejected. There was continued negotiation throughout the autumn and into the new year. And then in the new year, that was accepted. So I think some of this is about communication onward within the criminal bar of what the offer from the department actually is and what it looks like and what it would mean. So that's now agreed. But we agreed that within days of having met on the 15th. Yeah. It could have been agreed last August. So what I'm saying is, if you look at the individual issues, like for example, they've raised issues around a pilot for additional written work. That's also been now agreed. So those are two things that are now, were part of their 6-stage ask. I think the 6 items, there 2 of those have already been resolved outside the accelerated process. There were another couple that were going to go into the accelerated process, and then another couple that would just continue along the normal Burgess process. And of the ones that were coming into the accelerated process, I don't think the difference between the department and them was insurmountable. But what is a challenge is the refusal to return to service during the process. And if I contrast, the SCBA have not withdrawn service at any time during this dispute. So the Solicitors Criminal Bar have continued to meet their clients, continued to represent their clients, including in the High Court, have continued to do the work that they have contracted to do with their client. And we have continued to work with them and make progress and deliver on the asks that they made. They haven't withheld service in order to make that progress. In fact, bizarrely, I think they have gained slightly more from the process, even though they have still been working. I mean, the idea that I can do things that are fanciful simply because of the withdrawal of service, it's not true. If it is possible to do this and to find a solution, their being at work or not at work in the Crown Court is neither here nor there to the solution, because I have to justify the solution based on value for money, transparency, accountability, and all of those other measures. That's managing public money. I can't do something that doesn't fit within that, irrespective of whether the bar are at work or not at work. And I suppose that's the challenge. I would like to see people return to work, and if in a graduated way. If they'd come back and said, we'll go back to where we were in December, and we'll review that at the end of the process, that would have been a conversation to be had. But they actually said they won't go back to the pre-December or the pre-January position or to full service for as long as the review is ongoing. And then you get the situation where these cases are corralled. You have victims and witnesses, care unit, victim support, saying that these are extremely vulnerable victims. And then you have a kind of faceless group of people deciding whether or not they can have justice. And I just don't think that that is fair, because bear in mind that some of these cases, their clients will be the defendants. Okay. So how would it be ethical for me to say that those who are defendants in these cases decide whether or not they proceed? That's kind of contrary to natural justice.
Okay, well, I know you've only just received the letters. I mean, they talk about, well, recommending a graduated return to service, with first priority being to accelerate and expand a range of high priority cases affecting the most acutely vulnerable individuals. Well, anyway, that can be tested, you know, if some progress, and we're all concerned about those who've long awaited cases not able to progress. You mentioned earlier about the Vagrancy Act and whether or not that will be able to proceed. You'll be aware, some of us have spoken about concerns that repealing it could leave gaps in both protection for the public and for police powers to deal with nuisance behaviour, and proposals for legislation which exists in England and Wales and also in the Republic of Ireland around being found on premises with intent to commit an offence, begging causing harassment, obstruction of public order concerns, and offensive organising, controlling or facilitating begging by others. So whether or not that proceeds at this stage, I mean, would you have been open to considering whether those additional powers are needed by the police and to protect the public?
Well, we did consider it, so we liaised with the PSNI before we made a decision. I actually started the liaison on this in the last mandate, and PSNI assured us that the only thing that they would not have power to deal with was what they described as simple begging. So that's somebody asking you, can you spare a few pounds or a couple of pence? Harassment, blocking of premises, intimidation or threatening behaviour, causing alarm and distress, public order offences are all already on the books, and PSNI indicated that they did have the powers. For example, if somebody's blocking a doorway, if somebody is causing alarm or distress to people in a particular locality, they would still have the power to deal with those issues. So we actually did consider that as part of the overall consideration that we gave. We also, in previous iterations of some bills in Westminster, asked PSNI for their views on some additional powers that were available and whether or not they wanted them, and at that time they said they didn't feel they needed them. So they weren't sought at that point on the advice of PSNI. But I'm pretty confident, Brian, if I'm honest, that the issue that we need to deal with here with vagrancy isn't a criminal one. Poverty is not a crime. Being destitute is not a crime. Being desperate is not a crime. And it is Dickensian that people could be threatened with arrest for simply rough sleeping or asking for a cup of coffee or a sandwich in desperation. The thing that worries people, so there should be interventions in that. I don't disagree. I'm not sure there should be police interventions. I actually think they should be health interventions. I think they should be housing interventions. And I think that that's the space that we need to move into. I also think that where people are conducting themselves in such a manner that they're disrupting somebody else's business, where they are conducting themselves in a way that is causing a breach of the peace, there are laws in place to deal with that. Those are crimes and those are genuinely policing matters. What the vagrancy laws do is actually criminalise poverty. And I think we should, in this day and age, have better methods of addressing genuine poverty and destitution than criminalisation. And so from my perspective, I don't think it's right that people who are simply begging, nothing else, not harassing people, not frightening people, not causing a breach of the peace, not disrupting somebody's business, but just begging, I don't think that person should be open to arrest or threat of arrest for that purpose.
Yeah, well, rehearsing all the arguments, nobody's saying that you arrest your way out of the issue of either rough sleeping or people begging, that there are social issues there. But many people do experience intimidation or disruption of their business, you know, when those activities are happening in a way which is causing disruption and intimidation. And I have heard from the police that they would have had concerns about the powers, sufficient powers being there, but that'll be part of a process.
Well, we could certainly provide the feedback that we've had from PSNI if it's helpful, but they did not raise those issues with us. They said the one thing that they would not be able to do is essentially move somebody on who is simply begging under threat of arrest if they don't move. That's the only power that they would lose. Everything else you mentioned, well, first of all, and we've spoken with the PSNI about that, there is very little evidence of organised begging and that kind of abuse of poverty in Northern Ireland, but it is obviously something that we are very alert to, and they would have powers to deal with.
We're very happy to share
Yes,
some of that,
we'd
Chair.
be happy to.
Right for
It's a conversation, Brian, to be clear, that I'm open to have. I would like to see it changed. I understand the reservations. I've met with businesses who are concerned because of their own experiences, but it's a conversation where I would hope we would be able to evolve through that conversation to a point where we're able to actually repeal those particular pieces of legislation and then look at how we do respond in ways that actually support those who might feel intimidated or fearful or worried about their businesses.
One last question. In terms of hate crime legislation, you mentioned this earlier. If someone refers to someone according to their biological sex rather than their preferred pronouns, is it your intention that that would actually be a criminal offence which could result in prosecution?
No. That is not a criminal offence. it may be impolite, and some people might find it offensive, but it's not against the law to be offensive.
And it wouldn't be your intention that that would be against the law?
No, the reason that we've done the aggravator model the way we have is that we're not creating new offences. So what the hate crime legislation that we're bringing forward does is not create a suite of new offences, because I don't think that's helpful. What it does is look at existing criminal. So if you can be arrested for something right now, it could be aggravated if your motivation was hatred of a protected group. So no is the answer in short. If you followed somebody round the town daily, abusing that person, that would be harassment. And if you did that because that person was transgender or gay or an ethnic minority or part of a religious group or whatever, then that could be a hate crime if it's proven that it was motivated by hate. But it would have to reach the threshold of actually being a crime first. And referring to people by their pronouns, either chosen or otherwise, is not on the statute books as a crime anywhere. So this is not about criminalising people either through error or principle who won't use people's preferred pronouns. It is about protecting people who, for example, may face assault, physical assault in the street because they present as transgender and somebody has a hatred for transgender people. But it's not going to intersect with the majority of people who, frankly, want to get on with their lives and live peacefully and quietly with their neighbours.
I'm going to ask Ciara then to come in. She's the last person to ask questions, Minister. I want to thank you for your time here. I'm going to go. I have to go. I can't believe I'm out of the room before you are, but that's the case, and my able Deputy Chairperson is going to take over, so I'll hand over to Ciara.
Thank you, Mr. Chairman, for chairing things so well, and I'm sure everything will just be every bit as smooth in your absence. I promise I will behave.
Thank you. Ciara?
Okay, and thank you, Minister, for spending the time with us today, and it's quite detailed overview that you gave and looking and highlighting the key progress. I had three areas I wanted to look at: barrister strike, legal aid and court reform, but I know there's been loads of discussion on the current barrister strike. And for someone who does not, I know you don't take lectures, as you noted. I think yourself and barristers and our victims and ourselves, we're all gravely concerned and we want it remedied as soon as possible, because we do hold our barristers in high esteem, and we want to retain that. And I know that you haven't had time to digest the response, and I only got reading it myself just before this meeting. But on the basis of when you get to read the response, I would ask that some consideration would be to reinstate the accelerated review, if potentially, or mediation as was recommended by the Lady Chief Justice. So that's just me noting, given the fact that you haven't had a chance to read their response. Just the core thing I wanted to look at, which I'm very passionate about, there has been loads of progress in the rollout of solving justice, like your mental health courts, your substance misuse, your domestic violence perpetrator programs, and they seem to be having real good success, particularly around problem solving around reoffending. So it's just like to ask from your perspective in the department where all that is at. Thank you.
Well, in terms of problem solving justice, we know that is the best way forward in terms of actually dealing with reoffending, and in particular, if we are able to get people into a position, for example, where if they have substance misuse issues, that those can be addressed, if you like, as a precursor to considering sentencing and so on. There is an incentive there for people to engage, which can often help. They're not a panacea for all woes, but they can certainly be very productive. They do, however, they come with an intensive resource requirement. So, for example, I think I'm correct when it comes to the drug, the kind of problem-solving courts for substance misuse. Most of the substance misuse support, so the kind of health supports that were put in place, actually were commissioned by the Department of Justice and paid for by the Department of Justice rather than by the Department of Health, in order that the pilot could could be undertaken. If you contrast that with the situation, for example, in Glasgow, the Department of Health run the desistance programme, the Department of Justice run the courts, and they sit side by side and work together. And it is expensive for us to do to commission those services, largely from community and voluntary sector organisations who have a lot of skill in this area. Obviously, ideally, I would want to be in a position to say, you know, that will continue, and it is certainly our intention to try to look at that. But it is challenging in terms of resources, because we are essentially stepping into the space for good reason. The other departments are not, and that will require some challenge. We've also looked at enhanced diversionary options. So we're looking at things, extended custodial sentencing and so on, and the ecosystem, which you've all been briefed on. That's something that, again, I think has huge potential. And I know recently colleagues from England, Scotland and Wales were seeking updates on that from me, because they're very interested in how that could work. One of the challenges we have there is the ability to have positive requirements in the system, as opposed to simply limitations on what you can do, and we would like to be able to do that as well. In terms of youth justice, obviously the diversionary element of the work there is also helpful. The out-of-court disposals piece, which will come to you as well, actually the evidence is that when people on a first offence are given a fine, and it's quite immediate and impactful, that the level of reoffending is quite low in comparison to somebody who on a first offence gets a custodial sentence. Similarly, probation tends to generate better outcomes in terms of not reoffending than a short custodial sentence. So you're comparing like with like. So there are opportunities, I think, to do some work in that space as well. All of this will require some investment, but potentially can unlock resources further down the kind of chain that we have. But it all requires a properly funded system in all parts. We need a properly funded prison system, a properly funded court system, a properly funded probation service, as well as a properly funded police service. So it is going to be challenging for us. We are also looking at electronic monitoring and how we can better use that to deal with some of the challenges we're facing around remand, and also the monitoring of higher risk offenders. So that's something that we're exploring at the moment. And whilst at the moment those are not GPS enabled, they could potentially be down the line with the right resource implications for that, which would allow us to monitor in real time where people go, what they do, and to be certain, particularly for high risk offenders, that they're not doing things they ought not to be doing. At the moment, we can only tell if they're where they're meant to be or not where they're meant to be, which is a limitation on the information that we're able to gather. But we're looking at all of those options, because ideally what we want to do is take as many people as we can safely take out of the prison system and try to rehabilitate them in the community. Where we do rehabilitate in the community, it sticks and it tends to be much more effective. It's easier in some ways for people to be rehabilitated in a prison environment, in the sense that their access to substances will be restricted, the regime will give them structure in their day, and a lot of the complexities of their life will have been dealt with by all of that. The challenge is how they then transition out back into the community, where the pressures and the challenges and the chaotic lives start to invade into that space again. Maybe their medication is being properly managed in prison, but not well managed when they're left to do it themselves in the community. So if we can rehabilitate people in the community and give them the skills to actually start to look after themselves and be more constructive and productive, that's often a much better outcome for them, for their families, and for the community more widely in terms of safety. And so that's always going to be our approach. The last one I'm going to mention, just which I think is quite important, is the pilot that's being run at the moment by the Tackling Paramilitarism and Organised Crime team based in DOJ, but on behalf of the executive, and it is dealing with young people at risk of essentially being radicalised into paramilitary or terrorist groupings. So young people who are identified as vulnerable in that space, who are potentially being groomed by paramilitary organisations for membership. And what it does is, on referral from local police who see the risk and the danger, they are referred into the programme where there is then wraparound support for them, for their family, education, intervention and so on. It's been running now for about 6 months, I think. The pilot has been running for about 6 months. At the minute, it's South and East Belfast. I think they're looking now to roll it out in Derry and Strabane. And it complements some of the work here you'll be familiar with, for example, around youth workers in the ED departments. Again, we have that in South East Trust, and you have it, I know, in Altnagelvin and so on. And it's about this continuum for young people of having the right kind of intervention by qualified and well-trained youth workers can often be more effective than a direct police intervention. It's often more cost-effective as well, but it allows that support to be put in place in the community that can often help young people desist. So far, the analysis of those who have been through the programme, and the reason we're looking to expand it to another pilot area, is that it has worked well. And I think Derry is a good example where there has already been good cross-sectoral working between the education authorities, youth workers, the health facilities, mental health workers, PSNI and others. So I think it's a really good example, and we want to trial it there to see, if it's working in one part, will it work somewhere else, or are things we can learn from the different experiences. So I think all of those are potentially quite positive things that we're doing. Again, I hate saying it, it's all caveated by the resource implications, but look, I think if we can find ways to divert people out of the justice system, ultimately it's better for society. If we can find ways of helping people to live more productive, healthy lives, it's better for health and communities and for justice. So it's about intervention at the earliest point possible, and that's really our focus, because I genuinely believe there could be cost savings if we were able to do that early intervention. The difficulty and challenge we have is the firefighting at the other end, which consumes so much of our resources on a daily basis.
No, thank you for that, and I really appreciate, obviously, the varied amount of work that has been ongoing work that the department's doing with communities, and obviously I very much welcome the pilot coming to Derry as well. Just one final one, Minister, if you'll indulge me, and it's obviously the legal profession itself, and it's particularly young students. You are aware of CBA, obviously, and the recent kind of scholarships that they provide for probably working class students, parents and carers, and those obviously particularly and further fields like Derry and Strabane, there's significant barriers in entering into the legal profession, including the high cost of training, the substantial debt burdens, and just obviously the structure of the training based in Belfast and the travelling, etc. What more maybe could you or the department intend to do to increase access for particularly underrepresented groups and those that are furthest away from the likes of Belfast, where you have to travel for the training, etc.? Thank you.
So legal training and the requirements around that don't fall to the Department of Justice at all. In fact, oversight of the profession is a matter for the Department of Finance rather than the Department of Justice. However, there are areas where we can, I guess, lean in and be supportive of the work that's being done. I've talked about some of the reform of the Enabling Access to Justice system in order to try to assist with entry level, for example, people coming through having staged payments and interim payments for newer solicitors and barristers. You're right, there are huge barriers. And I am very pleased, I have to say, that in my experience in dealing with the professions, they are very focused on removing those barriers and wanting more young people to come through and be able to have a career in the law. I think part of the challenge is, as we discussed earlier, solicitors choose the barrister of their choice. That will often be based on the fact they know them or have worked with them before. And so it can be very difficult to break through and make a name for yourself and get seen so that people will offer you the work. And that can be a real challenge. And there are no simple solutions to that, but there are some things that we can do to help in terms of trying to ensure that there is a better distribution of work across the profession, and that people who actually want to learn and want to be able to enter the profession are able to make a sustainable career out of it. But much of it will lie with the professions themselves, who set the standards, and who, if you like, are ultimately the gatekeepers for the profession in terms of their standards and qualifications and all of those things. You know, we are fortunate in Northern Ireland. We have a very talented and very capable and very professional cohort of legal professionals, and notwithstanding the challenges that we have with the CBA at this point in time, I wouldn't want anybody to think that in any way I am disparaging of the bar or the barristers that are out there doing their jobs, or solicitors who are working with their clients on a daily basis. That is not the case. We are very fortunate to have some very skilled individuals. What I want to be assured of, though it isn't directly within my remit, it is of absolute, it's essential, it's critical to having an effective justice system, is that we have a sustainable legal profession, because whilst I can't dictate the terms of that and I don't regulate the profession, it's really important, if we're going to have justice, that you get access to legal advice, to legal guidance, and to representation and advocacy where you need it. And there are lots of ways where we can help in terms of particular areas of specialist advocacy, where we're able to offer funding and so on. We've pointed out things like these sexual offences legal advisors and schemes such as that, where we can offer advocacy in a slightly different way. There are also opportunities through the Enabling Access to Justice programme to look at you know, access to the different court tiers for solicitors and others who want to be able to do more advocacy work in addition to their regular work. And I think there will be opportunities through all of that for us to develop a more sustainable model going forward, but it will never preclude the need for highly qualified and specialist legal professionals in the bar and other places to deal with those really complex and sensitive cases, whether those be multi-defendant terrorism cases, rape, murder, and all of those kinds of cases. You will always need a cadre of highly specialised and highly professional individuals to deliver that, which is why, as I said at the beginning, I don't want to deny anybody fair pay for fair day's work. Nor am I trying to be constantly in conflict with the professions. I have a very good relationship with the Law Society and with the Solicitors Criminal Bar, and I believe that whilst this has been something of a hiccup in our relationship with the CBA, I would hope it's not terminal, because I still want to get back to the table and actually try to move this forward as a matter of urgency. I share your concerns with respect to victims, with respect to the impact it will have on the courts. I'm concerned about the cost implications of it, given the particular constraints that we face, but I'm also fundamentally concerned about public safety. And there will be, unfortunately, as a result of this prolonged action, potentially people who are guilty who will go free, and people who are innocent who will remain in prison when they ought to have been freed. And that is not justice. And so I want to make sure that that doesn't happen, and I want to bring this to an end.
Thank you, Minister.
Thank you.
Okay, Minister, thanks very much for that marathon session.
Thank you.
Thanks for coming before the committee. So, members, I'm going to give you all a 5-minute comfort break if it's required, because we've got more evidence coming.
Thank you very much.
Thanks.
Thank you, Chair.
Okay, so we are back in public session. So, members, now joining us, we're going to have departmental officials. We've got Lisa Bowl, the head of Police Peace Policy and the Legislation Branch in the DOJ, and Andrew Laverty, Bill Manager, Department of Justice. And they're here to discuss with us a number of matters relating to Part 1 of the bill, specifically biometric data and retention of such. So, members, can I remind you all that at last week's meeting we raised a number of issues that we required further information or clarification on from the department, We've got a list of issues that are included at paragraph 3 on page 350 of your meeting packs. We had agreed to write to the department to advise that we were actively considering a number of amendments, and the potential amendments in respect of Part 1 of the bill were the inclusion of photographs within the scope of the provisions in Part 1 of the bill and review mechanisms for biometrics. So at this point I want to welcome the officials.
I thought you were going to say you were going to wish us good night.
I want to wish you goodbye, unfortunately, but we're not quite there yet. So if you have any presentation that you want to provide, if you've already had sight of the questions that we've raised, or are you happy for us to launch into some questions?
I'm happy for you to lead the charge, Chair.
Okay, thanks very much. So I suppose we had some queries around whether or not the biometric data was going to include photographs specifically, and I think there was agreement amongst the committee that we feel that it should, and in order for the bill to be future-proofed, it should include provisions for photographs. If you could provide clarity on that.
No, I think we've explained before that the initial task in bringing forward this legislation was to address the issues around fingerprints and DNA. Photographs has been something that's been an evolving kind of area. We haven't included it in the bill because we want to take that forward as a separate piece of work. We want to look at not just the retention of images but also the use of images, given more recent developments around different forms of biometrics technology. So we want to take that forward as a specific piece of work, because I don't think it's as simple as just including the words images into the face of the bill and looking at it like that. We want to look at it in the round in terms of our policy on use of retention and images, and go through the proper policy development process, because we haven't done any scoping work, any consultation or impact assessment and all of that. So we want to take that forward, as a bespoke piece of work to think through all the various implications of that, and to bring that forward as a proper future-proof piece of policy, particularly in light of the work that the Home Office is now consulting on, and Scottish colleagues are working on. So we want to take that forward as a separate piece.
Okay, so I take on board the comments that you've made around the need for a more fulsome piece of work, but I suppose it would be remiss of me not to say that I think it's agreed amongst the committee that we feel that this is a missed opportunity, and in order to future-proof the legislation here, we're introducing legislation around biometrics, and this is obviously something that we all think of as biometric data, and so we feel that it is a gap.
If I could, I have no policy responsibility for biometrics or photographs, Chair, but from a Justice Bill Manager perspective, I would caution that bringing forward provisions at this stage where there hasn't been any policy scope and work done, any consultation, no options put to the Minister, no engagement with the Human Rights Committee, no engagement with the Attorney General, there's a very real risk that you're into the same realm of criticism that arose from the Media House JR judgment in terms of lack of proper proposals, lack of proper scrutiny, and that was a piece of policy that had been properly scoped and debated and consulted upon, and the committee had a full committee stage available to them to consider the options of that particular policy area. This is something that hasn't been looked at in any depth or detail. From my understanding of speaking with Lisa and colleagues in Police Division,
is clarified. That's okay. I want to just go on very briefly to retention of biometric data where somebody is in charge or convicted of a crime. So we had some concerns around the 2 year and then, or the 3 year and then the potential extension for 2 years. So just wanted to ask around that and what the clear picture is there and what the position is.
And that had been a provision that was previously included in the Criminal Justice Act of 2013, and that mirrored provision that's already in place in England and Wales and has been operating without any challenge or issues. So that was simply reenacting provision that was already made in the Criminal Justice Act 2013, and it's to deal with that very particular circumstance where the police can continue to hold that material. Somebody might be charged but maybe not convicted, but maybe they might go on to reoffend, and it's to have that material available for that very short period of time in case it does become relevant in a future investigation.
Thanks for outlining that. Maurice, going to bring you in.
Thank you very much, Chair.
I'm one of the ones that really be keen to see photographs included in the biometrics. However, I'm not going to die in a ditch if there's a better piece of legislation. Imminent, and I mean really coming down the road very, very quick.
It wouldn't be imminent in the sense that we still have to start the policy development work and consultation, and it will take a bit of time to work through that process. And obviously the other factor is that we're in a, there's no more space left in the legislative timetable of this mandate, so it would be something that would be into the next mandate, realistically.
Yeah. You, Chair. Why I think it's important is because of the advances in photographic technology and AI. We're leaving ourselves open that technology is going to evolve ahead of this bill, and we're going to miss an opportunity to have an important piece of evidence included within the biometrics, and that's my main concern.
I appreciate that concern, and that is why we want to take the time to look at the issue properly to make sure that we are taking account of the various issues and implications, but there's just not the time or capacity to do it, to include it in this bill.
Thank you very much for that, Annie. Thank you.
I've got Doug and then I've got Brian. Oh, sorry. Gumleshkil, I actually think Ciara had indicated first. Go ahead, Ciara. Sorry.
No,
Keep missing that wee yellow hand.
Just like the previous speaker, and particularly given the fact that the PSNI are already this week are actively looking at ways of using AI facial recognition technology, and just the widespread use of it, it is a serious human rights concern regarding the privacy and risks of miscarriage of justice for people. And I think it reinforces the need for the photographs to be included. Now, I know you've noted that we need to ensure that there is robust debate and it's consulted on and stuff, but I'm just curious as to why it wasn't looked at in the first place, given that this is a huge issue, and given the fast pace of technology. So that would be one question, why it? And then secondly, what commitment could be given from the department in relation to taking it forward as quickly as possible, but obviously given a due process as well. Thank you.
Why it wasn't originally done was because this started off as a piece of work around amending the legislation to do with the retention of fingerprints and DNA. That's what's currently provided for in the PACE order, and our original task coming out of the European Court judgments was to amend the legislation to take account of those European Court judgments that came in 2010 and then in 2020. And I'm sure the committee's well versed in the history of this in terms of the various attempts that have been made previously to bring forward this legislation, but for one reason and another it just wasn't possible. We had the Criminal Justice Act 2013 in place, but it wasn't possible to commence that due to the legacy issues that had to be worked through. And then obviously we had various phases where the Assembly was suspended and legislative plans were changed. So this was our first. The work on fingerprints and DNA has been a long time in the pipeline, and this is the first chance we've had to bring forward that legislation. And that's why. So the initial task was always focused on fingerprints and DNA. Images has been a more recent development, and there's just it wasn't just factored in. And so we've been trying to finish off the original task around fingerprints and DNA before we would move on to that. And we are committed to taking forward work on images, but it would just be as capacity allows, because obviously we need to get this bill through first and then start the work on images, and that would be it would be a commitment for us to do as and when we have the capacity to do that.
I mean, I would seek to reassure Ciara about the legislative programme that the department follows, which is a rolling programme of analysis of bids that are received at semi-regular intervals over the course of a mandate around, where areas have been identified as requiring primary legislation cover, what kind of legislative vehicles are going to be needed to bring forward, priorities from Minister's perspective, from the department's perspective, from Programme for Government, from TEO's legislative programme. So there is an ongoing piece of work around sort of a continual scoping exercise around what are the priority areas that need to be considered. And we've obviously got a very congested legislative programme for the remainder of this mandate, but we're already working on scoping out those areas that'll be potential inclusions in bills for the start of the next mandate. There's always a lead-in time of a minimum of 6 to 12 months around identifying discrete policy areas, making sure that they're consulted upon, making sure that all of the human rights and Attorney General engagements are in engagements with the Information Commissioner's Office. So there's a dual process of individual business areas progressing their policy development, and at the same time Criminal Justice Policy and Legislation Division within the department are managing an ongoing rolling legislative programme. So in the not too distant future, we'll be putting out, we'll be commissioning an exercise to identify priorities for potentially years 1 to 2 of the next mandate, to see, right, what policy resource is available. You know, is it a priority for this committee that the next committee would seek to endorse? Is it something that the minister would? Is there areas that the minister is frustrated that she hasn't been able to progress this mandate, that she wants to be at the top of the pecking order for the next? So we're never working on a fixed basis that this is the programme and this is what's included and that's it. And again, I speak as someone with policy and legislation experience, but no detailed knowledge of the biometrics. But I completely understand the committee's interests in this regard. But it's as a Justice Bill manager, I would be very concerned about the prospect of something being dropped into the bill that could have serious unintended consequences, because there isn't the scope to the resource and the time to scope it properly, to make sure that something with the best of intentions ends up causing significantly more difficulties than it would seek to resolve. But
thank you for that. Look, I really appreciate the scale of the work that you are undertaking, and obviously the length of time it does take, and you do want to have a robust process. I would be interested, not for now, but if you could even furnish us to get clarity around the resources that you do have within the department and taking forward legislation, and so we can better understand the challenges, because it is quite frustrating that we're behind the times in the sense from a legislative point of view, particularly around technology when it's moving so fast. So look, I do understand and I appreciate we do want to ensure that there has to be an effective consultation, and when you set out, this wasn't part of it. So no, thank you for that. It's good to get an understanding, but it would likewise be useful to get an understanding of the resources that are available and what would be the ideal resource that you could have to assist you in the work that you do.
I mean, there's ongoing headcount exercises being carried out at the moment, and just anecdotally, I can talk about my own branch. I'm head of criminal law branch within CJPLD. I'm personally down a full-time DP and a full-time staff officer. So a team of 6 has been a team of 3 for 6 years. And we've recently got, we had a DP for 2 years who's just come off the grade 7 competition. So we're potentially at half strength, but we're trying to work within the priorities just within our small branch and division to see, can we utilise that recently promoted grade 7 person for another purpose? And that's about what do we manage now, which is a priority for the remaining time of this mandate, as opposed to the focus on future legislative programming requirements, because that's also an area which is resource intensive, and it's the legislative programme management is done on an across the department basis rather than individual divisions or business areas putting forward little pockets in a silo fashion. There's a lot of strategic oversight there at senior level, so, and that obviously cascades downwards.
No, thank you, and I get as important that our ambitions be matched by the resources that's required within the department for you to take the work forward. So thank you. It's good to get that better understanding. Thank you.
Okay, thank you.
Thanks, Ciara. Doug, sorry.
Thanks, Andrea and Lisa. Look, I really appreciate the work that you are putting into this. I know how complicated and difficult it is, and it's long hours. But there is a consensus, I think, within this committee that photographs need to be part of this. For biometrics. And I'll be really honest with you, I'm slightly surprised that wasn't picked up on earlier, because I think that was made known earlier. I think the sense, maybe it wasn't deliberately made, but I got the sense that we as a committee made that known quite early on. My concern now is if we're not going to put it in, that the committee might now decide to put in an amendment, or a private member might put in an amendment, in which case, regardless, I get a sense that this is something you're going to have to do. And I fully get the compressed time and the legislative programme, but that's what came out of the department. The department compressed that programme with 3 bills over a very relatively short period of time, and they're big bills, each one of them. So that's the problem of management from within the department in many ways. But I just get a sense, Andrew, I don't know what will happen if this happens, that somebody's going to stick amendment in anyway.
Yeah, well, I fully appreciate that, and we'll obviously work with the Office of Legislative Counsel to identify areas of fundamental concern at the soonest opportunity to see whether those could be addressed or not. I mean, I'm purely thinking off the top of my head. I wonder whether it's something that could be accommodated by an order making power that would create an umbrella provision by which future photographic provisions could be made by secondary legislation. And that would certainly be capable of being brought forward in a much quicker time frame, albeit it would still be with the committee's full scrutiny, and if it was a provision that required any such instrument to be brought forward on a draft affirmative basis, that would require debate in the Assembly. So I'm not offering that as a solution. I'm purely thinking of if we were told something absolutely had to be done, what means might that be accommodated in without creating the potential for, and I don't want to use the word mischief in out of context. I mean an MLA drafted amendment that looks perfectly like a piece of legislation because it's produced on a template, but the outworkings of it could have unintended consequences, as you well know.
I think the concern, Andrew, is, and I think Maurice highlighted it very well, is technology is moving so quickly.
Yes.
We had debates in the chamber where we talked about how AI is interacting with images now, and so technology is picking up. And if we're saying that biometrics, that photographs aren't going to be part of this, and we'll maybe look at it next mandate, you're talking about 2-3 years from now is what we're really talking, and technology will have completely shifted yet again. And I think the fear is, Andrew, in truth, is that when we come to debate and try to pass the legislation, it's just going to come up. Yeah. And that's the concern. And
it's likely to have support. Now, the only thing that I would offer from a department's defence perspective is that there were a number of amendments that were identified at the point where this bill was ready for introduction. Those had all been consulted upon. They had all of the proper engagements had been done, but there wasn't the opportunity for drafting to be complete for the intended introduction date of April 2025. We got hammered. I'm quite sure that you're very familiar with the criticisms that the department was faced with, that bringing forward amendments to the Justice Bill was bad practice, it was bad protocol, it shouldn't be happening. So I would kind of turn that around and say, well, we were working on the assumption that the amendment that we were already well advanced in terms of the preparation for it at the point of introduction and at the point where committee stage began. We were kind of reeling a bit from the criticism and got a sense that there wasn't the scope for us to talk about bringing anything further forward. So we're kind of in that scenario of this is something that the committee's very much in favour of, but is it still bad practice and is it still bad protocol, even though it has broad consensus around the table?
And to finish, I mean, look, I'll just say again, thank you for all the work you're doing on this. I know it's a heavy workload, but that's just the realities, I think, of where we could be. And I just want to raise it.
And it's not just this, and it's a part of, it's actually ironically a consequence of this particular bill having this extent of a consideration stage that, you know, there is no other vehicle by which anything else can be accommodated during this mandate, and there have been other areas that have got the committee's attention. I mean, the likes of the amendment for the PSNI vetting and barring list is an example where, as a result of representations that were made to the committee during your call for evidence, you know, there's a request there that the department's, you know, accommodating, and similarly with of course the big one, deepfake porn, you know. So I think we're doing the best that we can in the areas that are considered the most essential, but we completely understand the committee's desire to see this reflected as well.
Appreciate the rationale you've laid out. Brian, I'm going to bring you in, and I hate to silence anyone, but if you're going to mention the photographs as biometric, I think it's been covered.
No. Just want to clarify. I mean, the normal model is material is held for 3 years and could be extended for further 2. Is that?
That's under that particular provision. It's materials which are under Article 63J. So, if in that circumstance, yes.
Which is that be most cases?
No.
No.
No,
well,
the norm will be under the legislation that unless somebody's convicted, if the person's not convicted, the norm will be that the material will be deleted, except in those particular circumstances.
Not convicted, yeah. But if they are convicted, can the material be retained?
Yes, the bill sets out the various retention periods that would relate. It would depend on the disposal given, would be how long the retention period would be.
And in the exemptions or exclusions. You know, various terrorism, International Criminal Court, National Security Act, where there's different limits apply. Those are very serious offences. Would they generally be a longer time period?
It would depend on the relevant legislation that the materials taken under, because the materials taken under, they would be governed by the retention periods would be set out in the various pieces of legislation. The materials taken under, they're all reserved and accepted matters. So I think for the likes of terrorism offences, material would be retained indefinitely if a person's convicted, but those are retention periods set by the Home Office. Yeah.
I'd like to think there would be longer periods.
Yeah.
I mean, obviously, you want to avoid is that important evidence is destroyed.
I'm not quite sure what the retention periods are for immigration.
A future crime, you know, where it could be used. Okay, I have a question about the Commissioner, but we'll come on to that, I presume.
If you want to ask for clarification around the biometrics, Commissioner, that's okay.
Okay, well, the Commissioner, they'll be an employee of the Department of Justice, will they?
No, it will be a public appointment, so they'll be an independent office holder. So they'll be appointed by the Minister, but they'll be independent. In the same type of a model as you've got the prison ombudsman or the police ombudsman, they'll be independent. They'll not be
who are they paid by? They'll be a civil servant, will they?
They're not a civil servant, they'll be a public office holder.
Okay.
Their payroll will probably come through civil service payroll in some way, shape or form, but they will be an independent office holder. They're not an employee. They're not like a senior official within the department. They will be an independent office holder, independent of the department, independent of the Minister.
Okay. And is there a budget set for the Commissioner's office?
That will all be worked through as part of the department's budgeting process.
It's not specified at this stage then?
Not at this stage, no.
Okay, that's all, Chair.
I'm content enough. Aoife?
Thank you very much. So the Scottish Biometrics Commissioner has emphasised that biometric collection must be necessary and proportionate, and has successfully driven a significant reduction in the biometric data captured by children by police in Scotland. So will you commit to learning from the Scottish Commissioner around the safeguarding of children, given that it's a successful model from another jurisdiction?
I think that would be particularly important for the Biometrics Commissioner once they're in post, to take a lot of the learning from Scotland and a lot of the work that's been done there in terms of developing the guidance and the whatever that the Commissioner will be required to provide. So I imagine that they'll want to do that to ensure that, you know, the issues around safeguards for children and young people and stuff, and obviously we'll be updating the PACE codes as well, which set out various safeguards in place. So yes, I think obviously I can't speak for a future Commissioner, but I dare say they would want to learn from the experience of Scotland and the work that's been done there to inform how the legislation will work in future here.
Okay. Yeah.
Enough. Okay. Yep. I don't think we have any other members. So
Chair, could I follow up? Just in terms of you'd notified the department of your intention to explore 2 potential amendments for biometrics, and one of them included a review mechanism.
Yeah.
Is that a review for reporting purposes, or I'm just curious because we had additions to both the domestic abuse and the protection from stalking bills during the last mandate, and that was about making information available within a specified period of time, which would be used to assess the success or otherwise of the legislation. I wasn't sure if it was that kind of a review mechanism you're talking about, or a review of a function or a person.
No, a review, if I understand it correctly, to basically, I understand that that's good practice to insert a review mechanism so that you can...
Yeah. Well, as I said, I was personally involved in the protection from stalking legislation, and we've already produced the first report under that. And I would say the only lessons learned from that I would seek to have you consider is that there was a great desire for a great deal of information that wasn't readily available as part of the stalking legislation that we cautioned about at the time, but which was included in the legislation anyway.
I think it's just even in relation to the biometrics provisions, the Biometrics Commissioner will have a statutory duty to keep the legislation under review and to provide an annual report which will be led before the Assembly about how the legislation's working. So that's kind of an inbuilt review process there that will be, we see that is the role of the Commissioner, to report annually on how the legislation's working and to provide advice to the Minister on any changes that may be necessary, or changes, recommendations to the Chief Constable, whatever it may be. So that's kind of an already...
I understand that the Biometrics Commissioner, as laid out, would be ultimately answerable to the Chief Constable, and the Chief Constable would have oversight.
No.
So
the Commissioner will be independent and will have oversight of how the legislation's working.
Okay, I don't know if that satisfies the intent of those who wish to bring in that review mechanism, but
offered for your further consideration, Chair.
Appreciate that. And I think at the start of the committee meeting we had a closed session where we had considered some potential amendments in terms of the live links section of the bill, and I think there were some concerns. We didn't perhaps have the opportunity to go through them all in detail, but just around the confidentiality aspect for anyone in a custody arrangement to have a conversation with legal representation and have access to legal representation was something that was raised.
Is that the police live link provisions that are in the bill already? Right, yeah. Okay.
So potentially an additional clause and changes to clause 20, I think. I'm not looking at it directly here.
My memory's not what it was, so please refresh me in terms of clause 20.
Was it clause 20 the use of live links for police interviews?
Yeah. So that there would be a very explicit right to access to legal representation at that point, and that would be confidential.
There's a couple of things there. So clause 20, the arrangements for interviews aren't actually included in the primary legislation. That's all set out in the PACE codes. Clause 20 is about the responsibilities and functions of the roles and responsibilities of police officers in conducting and facilitating an interview. Clause 21 is to do with live links for the use of extension of detention reviews, and there is a requirement there that the person has to have had legal advice before they can consent to the use of a live link. So obviously in terms of, so there is that requirement for the person to have had legal advice there. The PACE codes will obviously set out more detail about how all of that's to be done in practice, and I think we've explained before that we'll have to make updates to the PACE codes to support the implementation of the live links provisions, and that will all be brought forward. We'll be bringing forward those amendments for consultation once the bill is in place, and that will set out all the various safeguards and stuff there in the statutory PACE codes. So they'll be out for consultation, as you know, once the bill would achieve royal assent, and that would be the place where all those various safeguards would be set out.
And I think we also wanted to insert a new clause to define what should be included in the reporting of anything that happens in a custody arrangement that's via live link.
Again, I'm not quite sure what you mean in terms of the reporting, because because obviously the live link is the means by which the extension of detention review or the interview is carried out. So the interview would be recorded and whatever in the normal way.
Yeah. So I suppose that it ensures the confidentiality and the safety of all involved. It will be a clause to ensure safeguarding, basically.
Might be a case of sort of quoting the PACE codes or the section of PACE that
that might already be covered in the PACE codes.
Two things probably need to be read in parallel rather than in isolation, but it's perhaps something that Lisa could follow up on in terms of setting out the PACE code specifics.
Yeah. And then a review clause for the effectiveness of these
live link provisions.
Okay. Again, that wouldn't be. I don't know that we would normally do that, but we can.
That's okay. I'm just
sure.
But this once we want to consider these. Ciara, you indicated.
It was just in relation to the review mechanisms. I just pull it up here again. I think it's very important as to define what should be included in custody records involving live link proceedings.
Again,
So
that,
it's just
that would be set out in the PACE code. So that would the PACE code would set out what has to be recorded in a person's custody record.
Okay.
Is that all?
Yeah.
Okay. And then in part 4 of the bill, does anyone have anything that they want to raise at this point?
I hope not, because we don't have any policy leads from part 4 of the
so
bill
I
here.
Just to put on the record that we have concerns.
I can bluff to a degree, Chair, but I'm not sure that I could go for the detail. But
getting déjà vu, because I think we were in this position before.
Yes, well, in terms of legal aid taxation, there's actually been developments in that regard, in that the legal aid taxation amendments have been drafted. And as a result of those provisions, there's actually an element of, and again, I don't wish to speak for those policy leads where I only have a very superficial understanding, but it looks as though the new amendments might make clause 28 of the bill that's already drafted redundant. So if there's concerns around the existing taxation clause of the bill, they might be addressed by the amendment, which we're due to share the text of with you as soon as practicable.
As soon as practicable.
Within the coming weeks.
Okay, thank you.
We've got the text of an amendment from the Office of Legislative Counsel, so policy leads and DSO legal colleagues are just going through that, quality assuring it to make sure that it delivers what's intended, and we want to do that before we would share text in case there's any future changes, and we don't want to be disingenuous and present you with something that would require further tweakage.
Okay, appreciate that. And then I suppose to move on, and I'll invite other members to come in if they wish, I suppose in terms of the amendment around removing the crime of vagrancy from our personal perspective.
Again, well, I don't have the policy lead with this, but as it stands at the moment, the Minister had to remove the.
I'm saying I'm content with the repealing of that.
Oh right, okay.
Sorry.
Sorry, I was doing an awful lot of mental gymnastics there to try and come up with something plausible.
You're quite okay. Any other members want to come in at this point?
Sorry, Chair, as I understand it, we've got You've got some questions and queries around part 2 of the bill, which is children's bail and custody. We're due to have officials available to speak to the detail of that next week. And if there's any other parts of the bill or any of the remaining amendments, we can certainly make policy leads, myself included, available to talk to the detail of those if you let us know what those areas might be.
Yeah.
That sound good?
Yeah.
Okay.
Yeah. Thank you very much. Thanks for
Pleasure.
coming before us again, and apologies for holding you, delaying you so long at the start. So appreciate your patience.
I'd rather we're here and available rather than the reverse be true that, we
They're looking at you for you.
I wish I could believe that, Chair. Okay, thank you very much.
No problem. Thank you very much.
See you next week.
No bother. Members, we're going to move on to the next item on our agenda, which is item number 7. And here we have some written papers in response to some questions that we had previously had to the PSNA. So I'll invite members' comments or queries at this point. If not, I'll assume we're all content to note. We can move on to part 8. So agenda item number 8, which is a piece of correspondence relating to the sentencing bill pre-legislative scrutiny, and if members are content to note that. Yeah, happy days. We had previously been set to discuss PACE codes at agenda item number 9, beginning at 4:09 of your pack, but since this meeting has went on considerably longer than previously intended, I think we've agreed that we're going to postpone that to another session if members are content. Happy enough? Okay, members, I direct you into item number 10, which is the correspondence memo. Sorry, I've got my chair's brief here somewhere. So you'll find your correspondence memo beginning at page 1009 of your meeting pack, and we've got 7 items of correspondence there, and I want to draw your attention to 2 items in particular, and that's 10.4. There you'll find the Survivor Council has written to the committee proposing that the organisation serve as a formal consultant to the committee on issues relating to childhood sexual abuse and wider sexual violence. If members are happy that we agree to add their name to the list of stakeholders. Yeah, and can I then refer you to item 10.4? I don't know why we've got 10.6. Got it listed as 4 here for some reason. The committee has received further correspondence from the Causeway Dog Rescue requesting a review of the committee's earlier decision not to undertake a formal investigation or inquiry into animal welfare and oversight within prisons. Members, there appears to have been some confusion about an FOA response which had been issued to CCDR by the Prison Service, not by the committee as appears to have been thought. In addition, CCDR did not receive a further letter from the committee that was issued after the request for review dated 18th of November that had been considered at meeting on the 27th of November. That letter reiterated the position of the committee's initial response, which is at page 1147 of the meeting pack. Members will see that the clerk has clarified the position and that the committee has already reviewed its decision. CCDR has responded to say they will reconsider how to progress these issues. Is everyone happy to note? Yeah. Happy days. So then you'll find agenda item 11, which is the forward work programme. The latest draft of our forward work programme can be found at pages 1260 to 1266 of the meeting pack. Is everyone content to note? And can I remind you that we're receiving oral evidence from the PSNA and the Public Prosecution Service on delays in the criminal justice system next week. And does anyone, do we wish to have them appear jointly or separately? Does anyone have some strong views?
Jointly would be helpful, to be
Jointly?
honest.
Sure, can I come in there as well? Just
Yeah.
this was an item that was raised by Patsy McClone, and Patsy's preference was that they would come jointly. He's clarified that just before the meeting, so we've been in contact with both of them. They were preparing for both contingencies, so we'll do it as a joint session if the committee agree.
I think that would be more helpful. Yeah.
Everybody are happy with that, yeah? Okay. Then we've got chairperson's business, and the chair's not here, so we have no chair's business. And agenda item 13 is Ian Grow Ella. Does anyone have any other item of business they wish to raise at this time?
Oh, no.
No. Happy days. Agenda item 14, date, time, place, next meeting, Thursday the 12th of February at, do we want to go 1:30 or 2 o'clock?
When? It just depends on how long, because obviously the deliberation stage wasn't the thing that took long. We put it over time today, so don't know what are the kind of proposed timings so far for next week.
Community in the morning.
Oh, you have another committee?
Stick with 2.
It's 1:30, it's 1:30.
We'll do 2, I think.
2?
I'm easy.
Yes. Happy days. That's us.
Well done, Chair.